time permit,
If
matter
time
may be
permits.
taken.
What is this matter?
Criminal I.
In the appeal.
Not in a bill, in bail application. Bail was granted, but the condition that has been imposed, it has become practically impractical to execute.
Okay. There is a judgment by, I think, Honorable CJI of Mr. Justice Gawai, that if you impose conditions which cannot be executed, then it's like no bail. Okay, time permits.
Obligation.
Yesterday's matter?
Yes.
Oh, you have filed it so soon and you got it listed?
Yes, Your Lordship.
Sure. Okay.
May I please, Your Lordship?
Yes.
Your Lordship. This is a criminal revision petition which was filed under section 442, with section 528 of BNSF 2023 for the recalling of the impugned order dated 18/3/2020.
21/3.
Actually, this is the arrest. Well,
Okay. And also the other.
yes.
In the cause title, of course, you did not write that. In the prayer, you have only challenged 21/3. Right. Only 21/3.
Yes, it was mistaken. I forgot to write.
Again, you missed out. If there is no prayer, how can I give you?
Yeah,
Where is 21/3 order?
page number 27.
This was that recalling was rejected.
Yes. NBW was issued on 18 March.
Okay, this will do.
This is the last order, Lordship.
This is the last order.
Yes.
This will do. So what do you say? One day absent.
Yes, Lordship. As Lordship has yesterday also is inclined to Lordship, then it's okay, Lordship. Only because of the mistake of the council, why
yes.
is that is there.
Okay. But I'll leave it to the court to decide whether to recall or not. Okay. Because I will not give anything. Only that I can set aside this order. The rest court will decide. I'll tell the court to consider.
Yes, Lordship. Yes.
Heard, Miss.
See.
Kumar to rub my it has become quite bad. Heard, Miss. You are Sri Taba.
See.
Sri Ering, yes. Heard, Miss Sri Ering, for the petitioner as well as L. Hage. By this petition, the applicant had, by this petition, filed under section 442 of read with section, what is 442?
It's revision.
Revision.
Yes.
Along with this inherent power.
Yes.
This, I believe, not an interlocutory order.
And no, Lordship. This Lordship, it's kind of introductory order only,
But
Lordship.
she has also given inherent.
Yes, Lordship. That's why 528 is there, then is Lordship has the inherent power, Lordship.
Filed under section 442, read with section 528 of the BNSS 2023. For setting aside the impugned order dated 21/3/2025, passed in connection with POCSO case number 31 of 22 in ITA WPS police station case number 29 of 19, registered under section 376 IPC, read with section 6 of the POCSO Act. by which the recalling of NBW was rejected. Was rejected. Full stop. It is stated by Ms. C. Eric that the petitioner was appearing every day on the date fixed, was appearing on all the date fixed during trial, right?
Yes.
During trial of the aforesaid case. What is this annexure 3? This is on 18.3.
Yes, in the course case, it's in the course case also the name of the council was listed as L. Gillen.
Acha, acha, this is the cause list.
Yes.
Acha, where is your item?
Mine is item number 26.
And there your name is not reflected properly,
That's
right?
That's right.
L. Gillen.
Yes.
What is PP? PP is public prosecutor. T and Bagra. L. Gillen may be someone else who is representing the petitioner there? No.
No. L. Gillen, it was mistakenly actually. He was never appeared in this case.
He has not filed power and all.
No.
He was not there in the case at all.
Yes.
He has been appearing on all the dates, right? During the trial of the aforesaid case. However, one day, and that is on 18th of March 2025. Although the matter was listed.
Lordship, I have one small query, Lordship, because here, Lordship, victim was made party, Lordship, in the POCSO, then whether notice
That
should be served or not.
that I did not look into. Of course, that notice has, you have made her a party, yes, you have to. So notice, because every stage needs to be heard, right?
Yes, ma'am.
Now that you will be again given bail or the order will be set aside. So, okay.
Then your
got it.
interim may be given.
In the meantime, Lordship, it can be
What
suspended.
interim? Huh?
In the meantime, because then, as long, unless that is when this victim party will appear, Lordship, then this will be a dispose of, Lordship.
Otherwise, what interim?
Actually, your lordship, at least
Suspend the operation.
yes.
Yes, sir. It meantime it can be done, Lordship.
Suspend
Yes,
the
Lordship.
operation that he'll not be taken in custody.
Yes, your lordship. Actually, his parents were suffering a lot, so
He is not put to custody now.
he's in the
He's
custody
arrested.
till 21.
Okay, we will give that
Yes,
as
Lordship.
the main order. Okay, then what did I say? Yes. But however, in the cause list dated 18/3/2025, although I have said, no, although the matter listed, however, the name of the counsel appearing in the case was wrongly reflected. Who has not appeared, who has not filed any power in the said case. Who never appeared for the petitioner. As such, the petitioner could not be present on the date That is on 18/3/2025. And due to his absence, the learned court issued NBW against the petitioner with notice to his bailer. Pursuant to the same, the petitioner filed an application before the learned court for recalling / cancellation of the NBWD dated 18/3/2025. And the learned court, while order dated 21/3/2025, observed that due to the absence of the accused person, the trial of the case could not be proceeded, and accordingly, the accused was directed to be taken in custody by the court. It is noticed that there is nothing on record to show that the accused had willfully not appeared before the court on 18/3/2025. Neither it was noticed that he failed to appear on any other dates prior to the same. It is therefore ordered that in the interim, the order dated your interim prayer is be pleased to stay suspend Miss Case number 249.
Yes. Where the accused person was arrested on this date only. With the order of,
Suspend the order filed in the Miss Case. It has to be like this, I think. What do you say?
Yeah, Lordship,
Look at her interim prayer.
page 14,
Your Miss Case number was
249,
249.
yes.
Indian domestic case 249, Vita PS.
What suspend the Miss Case? Suspend the order passed in the Miss Case.
Yes, yes, order.
Otherwise, to stay this order, Lordship, till the Lordship, the victim party, Lordship, is made party,
This is
so
what
it's the
the-
notice with Lordship.
But then our prayer is incorrect. Okay,
It's
so
still, it's there, Lordship, it's stay or suspend, Lordship.
suspend the
Yes,
Miss
Lordship.
Case.
Yes, Lordship.
Miss Case was for recalling.
Order.
Miss case, Lordship, is the last order, Lordship.
Miss Case was filed for this reason only, for recalling.
Yes,
Right,
yes, Lord.
for recall.
Yes.
Yes, Lordship.
So on this date only the LS accused person was arrested. That's why Lordship.
Because of that order, he was again under
But if we
custody.
suspend the Miss Case only,
Yes,
then
Lord.
what will happen? We
No.
have to suspend the order.
Lordship, this suspend the order, Lordship, 21(3) is not there.
Not there.
Okay. Yes, Lordship.
Anyway, she has corrected already once. Because of the constraints of time that has happened. Okay, so what did I say? Suspends the in the interim, not the order dated. In the interim, the cancellation of the recalling order. The cancellation of the recalling order dated. Oh no, the cancellation of the recalling of the NBW dated dated 18/3/25 may be suspended till the next returnable date. Issue notice to respondent number 2 through the Office of the Registrar.
Office of the PP, Lordship, because.
Office of the PP as required under the law. List this matter after 2 weeks, 3 weeks. Okay? Be careful in drafting the petition. Facebook India Online.
Please, ma'am.
What happened?
My lady,
Your Lordship,
to provide,
I appear for the revision of a petition.
my lady, I'm being led by Mr.
See the council here. Acha.
Lordships have just switched it on. I'm so sorry.
Yes.
So Lordships, the petitioner is challenging order dated 1st of April. Now the issue before your Lordships is that the learned trial judge has not applied its mind, because in our application there are 3 principal things that he ought to have considered. Now the first thing is that I have no control over the Facebook service, so I cannot comply with any interim order passed by the trial court with respect to takedown of content. This is, your Lordships will keep in mind, a simpliciter takedown or defamation content. Now there are multiple judgments of what ought to be considered, but we don't have to be, concerned, because this is directly covered by a judgment of the Delhi High Court and subsequent judgments. So we had relied on the judgment of the Delhi High Court, which considers this issue, wherein our terms were clearly, it's stated that the service is being provided by Meta platforms, and every user on the Facebook service enters into a contract with Meta platforms. Now that was part of the application before the learned trial judge. Then there was a judgment of the Delhi High Court, Ajaz Ahmed, which was also quoted in the application, also produced. There is no finding given, and that judgment clearly, elaborately deals with it. And then there are multiple subsequent orders where Facebook India has been said to be a different entity, not having any control. Now your Lordship,
Let us go to the impugned order first.
yes, your
before
Lordship.
going
So
into the
Lordships will
judgments.
just have page 415 of the petition first. I just wanted to first summarize what the issue is, so then I can take your ladyships through the relevant judgments and the application and show why the impugned order deserves to be set aside. So your
No,
Lordship will have page 415.
Since you have prayed for interim order, I have to go to the order first.
Yes, your
Okay.
Lordship.
Just just read once.
So
Even he
Lordship,
can read it here.
so Lordship,
You are
yes,
there on behalf of him. Yes. He
yes.
can also read. There is some problem with the internet. Yes.
lady.
415.
My lady, in the interim order, the first part of the interim order records submissions, which starts in the instant application. Application is filed by the applicant under Order 1, Rule 10(2), praying for deletion of the defendant number 6, which is the petitioner, from array of parties in the suit. It is averred that therein that defendant number 6, Facebook India, it is not responsible for hosting the contents that appear on the Facebook service or any website, including the contested content. That applicant cannot provide for relief prayed for by the plaintiff, since it has no control over the content posted in the Facebook page, including the alleged defamatory post, and therefore applicant is not necessary party in the suit. Learned counsel for the applicant has relied on the annexure and submitted that Facebook company is now Meta Platforms Inc., that has its office in California, United States of America, which can only remove or restrict access to content, suspend, disable account in violation of provisions stated in the user's terms of service available online.
That means only Meta platform.
Meta platforms, please.
We are
So Lordships,
responsible for
if
that.
I'll just interject for a
Facebook-
moment.
Yes,
Yes.
Facebook India has no control.
Please,
Correct,
my
your
lady.
Then-
Lordship. So Lordships,
What-
there are two things to just to assist your court, Lordships. Now IT rules had also come in. So under the IT rules, there is an India office which every social media intermediary is required to maintain. So Meta Platforms office is in Gurgaon. So it is not as if Meta has not been complying with orders. Meta has been in India, has been complying with orders. There are multiple orders and they are passed day in and day out. So what your Lordships will then have the finding, heard both, your Lordships will have the last para, heard both the learned counsel, seen the application and the annexure. On perusal of the application, it appears that applicant defendant number 6 is engaged in online support services, including marketing, technical and sales support in connection for Facebook in India, in absence of any document showing exact nature of relationship between applicant, Facebook India and Meta platform, and related document, agreement, contract showing the legal liability in India being only that of Meta platform. Not of the, this court is of the considered opinion that presence of applicant before this court may be necessary in order to enable the court to effectually and completely adjudicate upon and settle all questions involved in the suit. Now, your lordships, this is the error. Your lordships will just have the application for a moment. Lordships, that starts at page 131. And I'll show from the application itself, that I have relied on all the judgments. To date, it was not even necessary for me to place a document, though which I had placed. So lordships will have page 134 of the petition. Now, lordships will see, I give the background of the application, and lordships will thereafter straight away come to page 140. So lordships may turn over, lordships will see now page at 140. Now, para 10, Facebook users in India enter into an agreement with Meta platforms, formerly known as Facebook Inc., when they register to use the Facebook service. So this is the first annexure I had put, and I'll show, this is also before your lordships, that this clearly says your agreement is between Meta Platforms Inc. Now, your lordships will see that my para 11 says what is the role that I play, and I give a categorical assertion in para 12 that I do not operate or own this Facebook service. I have no role to play. And then your lordships, very important, and para 13 always onwards, I give precedence.
What is the role of Facebook India then?
So lordships,
carry
it
on
is only, your lordships, it's only to promote Facebook in India, only marketing. So today we don't control the service, we have no role to play. And your lordships will have para 14 then. And I'll show the judge.
It's written in paragraph 11 that has been incorporated to carry on business inter alia online support services.
So lordships, not the main
Including
service.
marketing.
Yes, only marketing and technical to market Facebook in India. So it's more like a principal agent relationship that we just, we promote the Facebook service, Facebook group of products within India. So lordships will see para 14. I said from 13 onwards that these are the precedents. So para 14. And this judgment completely comprehensively covers all arguments which have been raised, and this is not being dealt with at all. So in Facebook India, so and so, and this is the Honorable High Court of Delhi determined that Facebook India was not a necessary party or proper party in a suit filed before Rohini District Court. In that case, the plaintiff named so as the party and requested the court requiring Facebook to action certain content. The court held that Facebook India does not control any content on so-and-so. Accordingly, High Court deleted so-and-so from arrow parties. So now, your lordships, my colleague will pass on this judgment, and I'll show that all arguments, and this has not been dealt with at all by the learned judge. So lordships will just have this judgment. My colleague would have passed it on. So lordships will have para 1, and the facts of this case are very instructive. So lordships will see, by way of the present petition, here also the petitioner is Facebook India Online Services Private Limited before the Honorable High Court. And this is 2013. And so the law has been, it's accepted day in and day out. Facebook India has not even made a party. It's been deleted regularly all across the country. So in 2013, by way of the present petition under 115 of CPC, the petitioner has assailed the order dated 30th May 2012, whereby an application under 110, which is again the same facts, for deletion of its name from the array of parties in a suit filed by respondent number 1 was dismissed. Respondent number 1, so again similar, had filed a suit against the petitioner and other parties who are defendants in the main suit therein for permanent and mandatory injunction, seeking that defendants may be directed to remove and permanently be restrained from posting alleged objectionable contents that are purportedly damaging the Indian culture, and so on and so. So lordships will then see that these are the facts, and the underlying facts. I will not repeat it. I'll just summarize it. That the court had held that I am a necessary party, and the plaintiff therein has said that, you are an Indian entity, and their Meta did not even have an Indian office, that, we will require it to for enforcing the orders. So lordships will thereafter, based on these facts, your lordships will see the consideration by the High Court.
No Supreme Court judgment on this point.
Lordships, it's not reached Supreme Court because ultimately whatever the plaintiffs require is to be implemented by defendant number 5 before the trial court, which is Meta Platform, which is already a party. So Meta will, if whatever order is passed by the court, Meta is already a party. We are appearing for Meta. We will comply with the order, whatever order gets passed. India has no role to play, and we will show. So it has not reached the Supreme Court because it has not been required, because it's been dealt expeditiously and quite adequately by the honorable high courts across the country. So your lordships will have page 6 of this judgment.
Yes.
So petitioner being aggrieved, these are my contentions which have been noted. And thereafter, your lordship will have para 12. It is admitted,
One sec. Para 12 of
the judgment only. I'm still reading the judgment, your lordships.
the daily judgment.
Yes, your lordships.
Yes.
I'm just, I can skip the facts, but lordships, I can straight away come to the finding, para 17. I just thought, your lordships can just make a note of it, how the court notes it, and then para 17 is what the relevant portion is. In view of the above mentioned cases, court is of the considered view, the impugned order is not sustainable and liable to be set aside for the following reasons. Petitioner has specifically alleged that it does not control or operate with the servers that host so-and-so who has filed his affidavit of compliance in terms of the order, which I have stated in my application here. The petitioner's written statement remained uncontroverted as no replication to the same has been filed, even in evidence in the following statements. It is stated the petitioner is not responsible for hosting so-and-so. Section 1 of evidence, the burden of proof, and clearly provides the party initiating the law so-and-so, so-and-so. Then, thus the evidence clearly so-and-so. Until such burden is met, the other party is not required to prove his case. The court must determine whether the burden has been satisfied. The court must determine the burden.
Go slow, go slow.
Okay,
You have gone through everything, so you are fast, and I have not.
So,
Okay, then.
lordship will have then para 20. It is also set matter of record. The respondent
Paragraph
number.
20.
Yes, your lordship. Subsequently, because it's just quoting the judgments. Then respondent number 1 himself filed an application for deletion of other respondents due to application of their names in the suits. These entities were the US entities of Google, Yahoo, Microsoft, YouTube, Exhibit respectively. Respondent number 1 did not object to the deletion of so-and-so and Google India, Orkut, YouTube India, Blogspot India, Zombie Time on the basis of the said entities did not run the websites allegedly hosting the objectionable content. It is also pertinent to mention that respondent number 1 filed an application for deletion Microsoft so-and-so, so-and-so, so-and-so from the RF parties. The learned trial court, by order dated so-and-so, deleted the aforesaid defendants in the suit. Petitioner is the only Indian entity remaining as defendant, despite that it does not operate or control Facebook as per the case of the petitioner. There is no contradiction of the said statement of the petitioner. Therefore, in view of the discussions mentioned above, the present review petition is allowed. The impugned order is set aside. Prayer made by the petitioner in its application for deletion of its name is allowed. However, the statement so-and-so by the petitioner suit shall continue during the pendency of the suit. So, Lordship, this is the first judgment. Thereafter, your Lordship will have the second judgment, which is Bechung Bhutia versus Soumik Datta. My friend will pass that on. These are just indicative orders because there are multiple orders, so I'm not burdening your lordships with multiple orders.
This is at page
Is
20.
the subject matter of the issue, like what contents they were supposed to remove or what?
Lordship, these are all defamatory matters, so the simplicity.
Only contents. Only
Yes, your lordship.
contents to be removed.
Only content to be removed. Here also, it's only defamation content, nothing else. And that relief has to be granted by defendant number 5. Lordships may record my statement also on this, that we are the only counsel appearing for defendant number 5 and the petitioner. If any order has to be complied with, it has to be complied with by defendant number 5. Petitioner has no role to play. I cannot even comply. And your lordship will just have one more judgment. Jindal Steel versus Kamdhenu versus Jindal Steel.
My lady, this is at page 212 of the petition.
212.
212.
Yes, your lordships. Lordships will have page 218. Senior counsel, this is the senior counsel appearing for Facebook Meta, which is now Meta platform. Senior counsel for defendant Facebook Inc. states that the relief sought in the suits can be complied with by only Facebook Inc. and not by Facebook India. And thus Facebook India be deleted. Then your
Facebook
lordship.
Inc. and the Facebook India are different.
Yes, your lordship. So Facebook Inc., the name has now become Meta Platforms, which is defendant number 5 in the suit.
Okay.
And Facebook India is the petitioner before your lordships. So lordships will then see para 23. I have inquired from the counsel for the plaintiff that once the relief claimed by the plaintiffs in the suits are undertaken to be complied with by Facebook Inc. and it is contended that Facebook India is incapable of complying with the said relief and does not have any control over the servers. What purpose will continue with Facebook India as the party will serve saving of delaying the suits in as much as experience shows that more the number of defendants, more delay in the suit. The counsel for the plaintiff then contends that in the event of Facebook Inc. not complying with the directions, there will be no Indian entity before this court against which action can be taken. The senior counsel for the defendant, Facebook Inc., on instruction states Facebook Inc. has not objected to the jurisdiction of this court in the present case. Even otherwise, once Facebook India is incapable of complying with the directions, and the same can be done by only Facebook Inc., even if there is any non-compliance, I fail to see as to how the same will be actionable against Facebook India. So, Your Lordship, again, this order as well. Now, Your Lordship can record my statement if any order has been passed with respect to takedown of content. That can only be done by defendant number 5 before the suit, and they will comply. Meta is already appearing in the matter. Now, Facebook India has no role to play. It cannot render any service, and Your Lordship will just have one more page in the petition, page 415. Lordship will just have page 415 for a moment.
Four one five, the impugn order.
No, Your Lordship, 415 is not the impugn order. No, I'm so sorry, Your Lordship. Page 257. 257.
415 is the impugn order.
Yes, Your Lordship. Lordships are correct. I meant 257. I'm so sorry, Lordships.
257.
Yes, Your Lordships.
One second.
It's 257. Where is?
Yes. These are what? MOU or what? These are what?
Lordships, I think I've gotten the page number. I think.
Lady, just to add,
Two-
the Honorable Guwahati High Court bench in the
Lordships,
Guwahati.
232 for a moment. Sorry, I'm so sorry, Lordships. In my copy, it's. Yes. So, Lordships will
Let him
see.
finish, I'll come back to you. 234. Yes.
232, Your Lordships. These are the terms of service which everyone enters into when they are entering into a contract. So every time you open a Facebook account, these are the services, the terms that you enter into. So Your Lordships will then have page 240. 4.5.1.
My lady, the terms of service are at 232. The overview section, the first page, the first page
4.5.1.
itself, 232, which is Facebook's terms of service. So
Yeah,
every
that I have seen.
Yes.
He wants to place some relevant part, I guess.
So the terms of service that we have annexed along with the Facebook India's deletion application, that also has the annexure, and it says that Meta Platforms Inc. is the entity in which users in India enter into an agreement with, and Meta Platforms Inc. provides this Facebook service to users in India. The terms of service are publicly available, and it categorically says that if users using Facebook are bound by these terms of service, that is the terms of service is referring to. These are at 232 and filed along with the deletion applications, which is at page 30. The deletion application starts at page 31, and the first annexure is also the terms of service. I'll just take my lady to the page number, the relevant page number of the terms of service filed along with the application, which is at page 149. It starts at page 149. This is the annexure filed along with the deletion application.
Wait, let me go through the impugn order once more.
Yeah.
This is 157. Lordships, I'm so sorry. It was actually 157. This was part of the.
I'll just go through the impugn order
Yes, Your
once.
Lordships.
I'll come back to you.
It was paginated in such a way that I thought 257. It was 157. This is what was there before the trial court. It will 57. That's how I remember it. This is 157.
there before the trial court, perhaps this relationship between the Facebook and the Meta was not pleased.
It
Right?
is there,
That
your
was
lordship.
the
Lordship will have page
submission.
157. That's what I wanted to show. That's why I was
Now
looking at
here
the.
it's there.
No, in
Here
the
it's
even
there.
before the trial court, it
Okay.
is there. Lordship will have page 157. It starts at 132,
In
the
absence
application.
of any
Page
exact
157, your
nature
lordship
of
will see.
relationship.
If your lordship will just have page 157, I'll just show there.
And the trial court had also stated that to adjudicate upon and settle all questions.
Lordship will
Now, I
just.
have not gone detail into the matter, but here it is said to settle all questions involved in the suit.
Lordship.
Right.
Lordship
There
may.
can be questions relating to any technical issue which the
That
Facebook
also
agencies-
Facebook in online has no role. Whatever, see, lordship, the ultimate, lordship may issue notice and ask them to file a reply, but ultimately it will be takedown of content. Now the plaintiff is aggrieved by circulation of defamatory content. Now for takedown of any defamatory content, as per the latest order by the Supreme Court and ANI media, there are certain parameters which are to be met. Now courts have to be cognizant of Article 19(1)(a) and freedom of speech and expression. Now if the court comes to the conclusion that this content is defamatory, now under the IT rules, under the IT Act section 79, the intermediary will take it down. Now that intermediary is before the court as defendant number 5.
And that
Either
is okay. Respondent number 5 is there. But then somewhere from the documents that you have just shown, it is written even online services were looked into by Facebook India.
no, your lordship, I will show that. So
So
lordship
let
will just
the notice be issued and your interim will be considered on that day after appearance of the other party.
no difficulty, lordship. The suit is listed on 1st of August, so lordship may give a shorter date if possible.
Yes, within July, the interim prayer can be heard.
Yes, your
My
lordship.
lady, if I may just get 1 minute to assist. My lady, just to add, the Honorable Guwahati High Court, Guwahati bench had considered a criminal defamation case earlier, also filed by petitioner here, and stayed the impugn order, which also summoned an employee of Facebook India. There also, the submissions made were that Facebook India is not the relevant entity which controls the platform or controls the server. See, the High Court had stayed the proceedings.
It
This
depends on the facts of every
facts,
case.
my lady.
But then here, I did not go into
The-
everything.
the-
Here, the trial court said that to consider all the events,
What
everything
we'll do, your
involved in
lordship,
the suit.
I
So,
see what.
I'll issue notice and
My
then
lady,
thereafter.
yes,
Okay.
I would just highlight that the prayer made in the suit is only takedown of content against me,
Yes.
and takedown of content. Meta has categorically stated that it is the entity which will take down.
Whether it is only taking down the contents, that will have to be again seen in detail.
Lordship may also, in the meanwhile, summon the original court record so that the entire court record is there, and lordships can consider before the
Yes,
when
court records will be necessary in order to see whether you
Yes.
have placed all those materials showing the relationship.
Yes, your
exact
lordship.
relationship.
So lordships may summon the entire court record. Then in that case, we can assist your lordships better.
Yes. Heard, Mr.
My lady,
Your
you
name?
only issue notice to respondent number 1 for the purpose of interim relief, which is the contesting defendant here. The remaining are pro forma parties here.
Uh,
For the
what are
purpose of
parties I've not seen?
yeah, the remaining are pro forma parties here, which are defendants in the suit.
Defendant number 1 is the plaintiff, your
Is
lordships.
the contesting defendant.
Is the plaintiff before the court.
You decide who will argue. Both of them you are arguing.
No, I'm
It's
just
okay. Respondent number 1 is the plaintiff, right?
Yes.
And 2, 3, and all those are according to you are performer, and so
Yes.
okay. Let the new notices be issued to all, and then interim will be considered on the next date. Okay. Yes. Right, Mr. Your name, please.
My name is Varun Pathak, your lordships.
Varun Pathak.
Yes, your lordships.
Heard Mr. Varun Pathak, assisted by
Tejpal Singh.
for the petitioner, as well as yes, for the petitioner, the instant petition is filed by the petitioner under Article 227 of the Constitution of India, challenging the impugn order dated 1/4/2025 passed by the Civil Judge Senior Division at UAPA, District Papampare, Arunachal Pradesh, by which the learned trial court rejected the application for a deletion of respondent number 6, of defendant number 6, that is Facebook India, from the title suit number 26 of 2022. The main ground taken into consideration by the learned trial court is that the petitioners did not place any documents showing the exact nature of relationship between Facebook India and Meta Platform Inc. / Meta USA, as well as the related documents showing the legal liability of Facebook, legal liability for removing the contents from the Facebook post published in India. The trial court further observed that respondent number 6, that is Facebook India, is required to enable the court to effectually adjudicate upon and settle all questions involved in the suit. Mr. Pathak submits before the court that in view of the terms and conditions, the Facebook India has no role in removing the contents from the Facebook page, and that the responsibility and that the task of removing the same only lies with Meta Platform Inc. Facebook, full stop. Facebook India can only deal with the technical and what purpose you said?
Lordship.
Can only deal
It's
deal
only
with-
an assisting entity, and it has no control over the servers. It provides marketing and technical assistance for Facebook's in Meta's platform.
it is only
Operations within
involved
India.
It is only involved in marketing and technical
Marketing,
issues,
technical, sales support.
Sales
and
support.
sales support in the country.
In the country.
Issue notice to respondent number 1. Issue notice to the respondents, including the performer respondents from 2 to 6, 2 to
2 to
6, 2 to 8. Returnable by 3 weeks.
Lordship may
Returnable
also
by
s-
2
also-
weeks.
Lordship may
Returnable
also
by
summon
2
the original
weeks.
records.
The interim order will be considered on the next date. I'll say that.
Yes.
And then the petitioner to take steps for service upon service of notice upon the aforesaid respondents by AD, by registered post with AD, as well as with usual process within 2 days from today. The interim order to be considered on the next date of hearing on the appearance of the plaintiff. If they do not required. No, interim order to be considered on the next date of hearing.
And Lordship may also summon the original records for the entire suit so that Lordship can see.
Yes. Since it is held in the trial court's order that documents were not placed to show the exact nature of Facebook India and Meta Inc., the trial court records may be called for. from the court of UPA, right? What civil judge, senior division, UPA.
And Lordships,
Okay.
what is the date your Lordships are giving? Could it be 28th July?
List the matter on. You
28th
suggest a
July?
date
That,
or any date to
my
be
lady,
fixed.
the next date before the trial court is 1st of August.
Huh.
So before that, a date
Let the matter be list the matter on
28th July?
31st.
No, 28th July?
Availability.
28.
Yes,
right?
your Lordship,
Okay,
28th.
28 July 2025.
Grateful, your Lordships.
Grateful.
May I please allow, this is a bail applications moved by the wife of the Ellis accused lawsuit. She is a housewife having two children. One of the child is a special child lawsuit. I see lawsuit. This was he was arrested on the basis of the FIR filed by the police office.
What is the offense? Murder?
Yes, lawsuit.
Okay.
Yeah, it's based on the FIR lost by the police. It's registered under New Delhi police stations lawsuit. If you see in this case lawsuit, you will find that.
Let me go through the FIR once.
Yes, it's a phase 15 years.
This FIR is lodged by the police personnel.
Yes, lawsuit. It's mentioned in detail lawsuit.
5-year-old girl.
Yes, only daughter.
Hmm.
She's the only daughter, having two son also.
Okay, everything is against the father. Acha. You have moved the bail application?
Yes,
on?
yeah,
For the father.
yeah.
Okay.
I have moved before the session court also, but if you see if you see in the FIR also, it's clearly mentioned. One is that she was in drunken state, Lordship. One another point, Lordship, nowhere in the FIRs mentioned about intention. That is very important. The intention, Your Lordship. There was no intention to kill the lone daughter. See,
No, the intention
yes.
knowledge will be seen in the
And-
trial court. But as far as the
Yes, sir.
bail is concerned,
yes, Lordship.
there are enough materials here. The wife has said the father has thrown the baby and because of that he died. What else you want?
Another
The wife had herself said, now she is the petitioner here.
Yes. So one, this is that, Lordship, I just want to mention, in this case, already charge sheet has been filed, trial has commenced, Lordship, and also the statement of the informant has already been recorded, Your Lordship.
The wife's
Yeah,
statement.
your wife, not informant, Your Lordship.
Oh,
In
the
this
police
case,
person.
yeah, in this case, the informant is the police person. All this statement also is already recorded. Your Lordship will find the peculiar circumstances which has been created because of the situation which is arise, Lordship. One is that she is a housewife, Lordship, and more of you will find in my petition also I clearly mentioned that he is the sole bread earner, and two a minor child is there. One is the disabled and another is also is a minor child, Lordship.
Two
And-
boys.
Yeah, two boys still have.
I mean, see,
Siddhi.
his conduct, I mean, you are admitting that he had taken alcohol that night and then he had thrown it. See, I mean, he is rather dangerous. He has two sons. He absconded rather. He fled, and then he had to be arrested from some other place.
Mhm.
So again, two minor child. One he has thrown. He can do anything with the other two.
Lordship.
So what I believe is he has been inside for
180 days, Lordship.
180.
Already.
180
Yes,
days.
Lordship. Already statement of the
And
information on
68, acha,
recorded, Lordship.
and what are the number of witnesses to be examined
It's mentioned, Lordship.
yet? I mean, and what did the bail order show? You had made a
Last Lordship, you will see in last bail orders which was rejected on 22/5/2000. It's on page 16, Lordship.
yes.
Five, Lordship.
The judgment that the trial court has referred is also of importance
Yes,
because
yes, yes.
in cases of these natures, the when the trial starts and it reaches to a certain point, it is not desirable that a person is given on bail.
Maybe Lordship, like that we fix. I pray Lordship to fix one date to argue in this case also, Lordship.
Otherwise, let
CD
me call for the
CD
records.
records, that's very important, Lordship.
TCR. If the witnesses' statement you have not annexed,
Yes.
so if the witnesses have not stated anything
Yes,
against that,
Lordship.
then it can be considered.
Case record may be called, that will be better, Lordship, because it's a mere allegations.
We will see in the
Yes.
depositions.
Yes, Lordship.
Okay, this is heard, Miss. Your name is.
Nina
you
Daman.
are legal? in
Yes.
counsel? Okay, legal in counsel K.N. Miley for the petitioner as well as Al Hage. This petition is filed under section 483 of the BNSS by the petitioner for grant of bail to the accused person, that is her husband.
Yes, Lordship.
That is her husband, Sri Ram Vilas Thakur, who was arrested on 1/1/2005 in connection with Nirjuli PS case number 1 of 25 under section 103 of BNSS Act 2023. Call for the case record, call for the trial court records.
Scan copy, Lordship.
Oh, scan copy. Call for the scan copy of the trial court records. List the matter, and what about notice and all? Not required. List the matter after 2 weeks.
Court vacations.
Okay.
There is a court vacation. That one date may be fixed, your Lordship.
Date.
Yes.
List the matter on 22nd of July,
Yes, Lordship, that week. Oblige you.
2025.
Oblige.
This is the petition again. What have you brought this time?
Yes, my lord, here also some mistake
Quashing
by the registry, because we have filed this criminal revision petition, but here costly is criminal petition. Registered as a criminal petition. It might be the mistake of the registry. So
A revision is also there.
yes, in my
442 and 438. 438 is what? Revision.
port at a record calling records.
Oh, earlier 397.
Yes, 397.
For quashing and setting aside the impugned bail rejection passed in bail application. Why bail rejection? You could have come under bail. What happened?
My lord, here offense is bailable in nature.
Then
Bailable nature. So in that case, for bailable offense, there is no provision for regular
why the
bail
trial
body.
court did not allow?
That's why we have filed and challenged the impugned order of the landed court below.
Show me the
Because,
impugned order. 1906.
Yes, 1960.
Okay, annexure 2.
My lord, bailable offense is a matter of right of the accused person, but however, the learned court below rejected the bail. Page number 13 is the imping order. Married. Order dated 19/6/2025. Srimati Lika Reena has filed application under section so and so through her learned counsel, so and so. So I'm praying for granting bail to the accused Sri Sani Vangsha, who has been arrested on 15/5/2025. Mr. Tanyang Tadolan Counsel, Special Public Prosecutor, NDPS Act, and Mr. So and so Counsel are present. I of the case has transmitted the update case diary along with the comment on the bail application. Mr. R. Gajmir, counsel for the petitioner, submitted.
Saying NDPS Act, all sections are non-bailable.
Uh,
There is a judgment in that Shah Rukh Khan's son's case, no?
Your Lordship, there are disputes in with regard to this because there was a case with regard to Riya Chakraborty, Your Lordship, by the where it was made it clear that all the sections in NDPS are non-bailable, Your Lordship.
Then
However, subsequent challenge was made before the Apex Court. Apex Court not specifically dealing with that, but then however stated that Riya Chakraborty shall not be a precedent, Your Lordship. Only that was regard. Otherwise, also in Bombay High Court, Your Lordship,
that Shah Rukh Khan's son's judgment.
yes, that was sent to a larger bench, Your Lordship, and we are still awaiting that issue. The only issue is that if all the sections under NDPS are bailable or not, Your Lordship.
Non-bailable or not.
Yes, non-bailable or not, Your Lordship. If Your Lordship can just issue
But
notice.
referring to a larger bench will of course not cause
Yes,
the
yes.
present.
Uh,
But as of now, what you mean to say is they can be bailable or not bailable. It's not a case that it will not be bailable at all.
yes, Your Lordship. I'm just,
Okay, let him finish. I have just
Yes.
inquired to see.
My lord, here
Yes.
FIR, the FIR is lodged against the
No,
one
let
main
me
accused.
finish the imping order.
Yes, yes, yes.
Against the accused, Gajmir counsel
Uh,
submits that the sections
yes.
are against so and so.
Uh,
Bailable.
Yes, Mr. R. Gajmir, counsel for petition submit that the section registered against the accused being 21A of NDPS Act, the offense is bailable under Schedule 2 of the BNSS. It is further submitted that the investigation agency have taken sufficient time to gather evidence if any additional charge were to be added against the accused. Mr. Gajmir further submit that co-accused Ms. Kyoda Orte, situated in similar facts and circumstances, has been granted bail by this court. As such, the present accused deserves the same relief by rule of purity. In these circumstances, he prayed for grant of regular bail to the accused and assured that sufficient surety will be furnished if he is admitted on bail. Mr. Tanyang Tado, Special PP NDPS, vehemently opposed granting bail to the accused, stating that he is found involved in peddling and trafficking of illicit drugs in the town of Jiro. Moreover, the supplier of the contraband is yet to be brought to the justice. Therefore, enlarging the accused at this stage will prejudice the prosecution case. Upon hearing learned counsel from both sides, I have carefully perused the CD. It is found that present accused had admittedly visited the supplier of contraband substance in Bandardeva and Harmuti on 10/5/2025 with Kyoda Ote, co-accused, who has been granted bail by this court. It is further revealed in the CD that after procuring the contraband substance from the supplier, the present accused Koda Ote, Modung Songko, and one Toko Jotam have distributed the contraband substance among themselves at New Delhi. It is pertinent to mention here that in the CD call for hearing bail application number so and so of Ms. Kyoda Orte, the investigation officer has clearly mentioned in his comment that she was not required for further investigation. Moreover, she has found only possessing the small quantity of suspected heroin. In the present case, the CD further indicates that present accused is not cooperating the investigation officer. More particularly, he is not disclosing the identity of the main supplier, who is residing in the neighboring state of Assam. in the circumstances as contended by the learned special public prosecutor NDPS Act, if present accused is released on bail, there is likelihood of him alerting the main culprit supplier of narcotic drugs and his subsequent involvement in similar offense. The factual position of the investigation being so, prayer of the special public prosecutor is accepted. In the result, the bail application is rejected. Mr. Taning Tado, learned public prosecutor, is directed to get instruction from the investigation officer with regard to his comment given in case of Kyoda Ote, that on what ground the investigation has not opposed grant of bail. With the above order, this bail application number 64/2025 is
It's okay.
rejected. My lord, here FIR, if we read the FIR of this present case, this FIR is lodged, registered against only Miss Kyoda Ote. My name is not reflected in the FIR. On being recorded by the IO, my name had been reflected by the main accused, saying that I was involved in this case. Only being statement recorded from the main accused, I was arrested on 15/5/2025.
Main accused otherwise is not arrested.
He was arrested and granted on bail by the same court.
Khoda.
Yes, Miss
No,
Khoda.
Khoda is a lady.
Yes.
And then, okay, no, in the bail, in this order, it is written that he is not disclosing the name of the main supplier.
That is residing nearby neighboring state in Assam. That is a ground taken by the investigation officer.
So his name was revealed by whom? Khoda,
Yes.
during investigation.
Yes.
That's how he is arrested.
Yes. And no
Show
such
me the FIR once.
uh,
The page number 11.
FIR is not, my name is nowhere reflected.
I'll
Only
just read it. I'll just go through it. It's okay. Khoda OT is peddling at 0 here. Okay. It was Khoda only.
yes.
In her house, very small quantity, of course, that was
Yes.
recovered.
Only,
And that was the ground for giving bail.
yes. And arrest memo is page number 29. I was arrested on 15/5/2025. Page number 29 is the arrest memo.
Now, so you're praying for setting aside that rejection order.
Yes. And police, as per their remand prayer of the investigation officer, that is page number 31. Here clearly, page number 31, that is a remand application, remand prayer of the investigation officer before the special court NDPS 0. Here
Where is that?
clearly, page number 31.
Yes.
Here page number particular relevant portion is page number 33. Prayer process.
Yes.
The progress of the case. That sir, on dated 15/5/2025, arrested person was produced before the learned court of Chief Judicial Magistrate 0 and obtained their 5 days PC, means police custody, for proper investigation.
During
And
remote period, alias accused was examined and
Yes.
accorded his evidence. Therefore, after expiry, the accused is forwarded before
Yes.
first judicial
5
magistrate.
days police custody has been granted from the learned CGM 0, and after expiry of police custody, accused has been forwarded for judicial remand. It indicates that their investigation part has been completed. Statement has been recorded by the police. The main purpose of arresting to the present accused person has been fully served. So, furthermore, my lord, the there why no such substance, suspected narcotic substance has been recovered from the present accused person. And as per the allegation, they have visited the main peddler at Assam and distributed the narcotics at New Delhi. The cause of action is also different. So I have no at all connected in the zero PS. Only because of the statement from main accused, I have been arrested. And now I am in the custody.
NXT forwarding report.
Yes, here bail rejection order here clearly indicate that I, along with the main accused, visited to the Assam and obtained some narcotic and share among themselves at the New Delhi. The cause of action is not fall within the zero jurisdiction. So, moreover, I have been in the custody for more than 45 days. So there is no further required detention in the custody. So I am praying for set aside the impugn order passed by the learned court below.
Yes, Ms. Rini.
Your Lordship, with regard to the issue that if it's a bailable or not, Your Lordship. Lordship, it remembers that Baldev Singh, there was just a small paragraph of a constitutional bench stating that the offences dealing under section 37 are cognizable and non-bailable. It was just a fleeting reference while dealing with other issues of the NDPS, Your Lordship. And with regard to that may be therefore kept open on the next stage, Your Lordship. And the other submission that is being made for that CD will be required, because if only on the admission of one of the accused, his name has been reflected and there was nothing found on him, Your Lordship, that would not.
So I'll give him the interim and then in the meantime CD. And whether it's bailable or not, that will be left
I'll be
for examination letters. Okay. Heard Mr.
Tartorum.
Yeah, Tardora for the petitioner and Ms. Ginny for the state. This is an application filed under section 442 and 438 of BNSS 2023 for quashing and setting aside of the impugn order dated 19/6/2025, passed in bail application number 64 of 2025 in connection with 0 police station case number 32 of 2025, registered under section 21A, small a, within bracket, of the NDPS Act. Full stop. By the said order dated 19/6/2025, the bail application of the petitioner was rejected. That was a bail application, right?
Yes, Your Lordship.
483 is what? Oh, yes, by bail application. Was rejected by the Court of Special Judge, NDPS, Lower Subansiri, 0. Lower Subansiri, Kurung, Kume, so many areas?
Yes.
Arunachal Pradesh. Lower Subansiri, Kurung, Kume, Kamle, Kradati. You have to write all this or not required? Kradati districts, headquarter, 0. You can write only 0, I think. 0 Arunachal Pradesh. The prosecution case as is unfolded from the FIR is that on a credible information received from the informant, the police personnel from police station 0 arrested one person, namely Miss Kyoda Oti, on the charges of keeping contrabands in her house Full stop. On the said information, the police personnel with the team and by following the necessary requirements under the NDPS Act. At first, search the body of the said accused person, namely Miss Khoda Oti, and being unable to find any contraband in her body, they searched her place. And on being unable to find any articles from her body, they searched the house. And during the search, they found hidden packet in white bags kept below the bed. And as such, they found 2 numbers of plastic vials, 14 numbers of empty vials, and 2 numbers of insulin syringes. The police has such registered the case under section 21A of the NDPS Act. Thereafter, during investigation, the name of the petitioner surfaced. Full stop. The Mr. T. Toram, appearing for the petitioner, states that the offences charged against the petitioner was a bailable offence, and in spite of the same, the trial court did not allow bail. The trial court recorded that the case diary revealed that the petitioner visited the supplier of the contraband substances in Bandardeva and Harmoti with the arrested accused, Miss Khoda Oti, and procured the substances from the supplier and distributed between him, Khoda Oti, as well as other accused persons. What did I write? What did I say in the beginning? I mean, before the last part of this sentence, he submitted. Then, okay. The trial court further by considering the factual position of the investigation, inasmuch as that the petitioner has not disclosed the identity of the main supplier and also on the submission made by the public prosecutor that if he is released on bail, there is likelihood that he will alert the male culprit. He will alert the male culprit and the entire record will not be revealed. Ms. T. Genie submits that as far as the contention that it is that the offense in question is a bailable offense has to be looked into in view of the fact that there has been observations by the honorable courts that the offenses under the NDPS Act are not non-bailable. However, the same has not been settled. As such, she prays that the matter, that the question in this aspect may be left open during the hearing of this case. I have heard the counsels and have perused the records. It is prima facie noticed that the petitioner was arrested on the it is prima facie noticed that the petitioner's name was not reflected in the FIR and that he was arrested during the investigation. It is also it is not clear from the records from the present case. No, from the documents annexed by the petitioner as to how the petitioner was arrested, whether it was on the basis of the statements of the co-accused or on other materials. However, the fact remains that he was not arraigned as an accused in the FIR. Further, what is the quantity received from you? What?
Nothing.
Oh, you say nothing.
Yes.
Okay. It is also not clear as to what was seized from the applicant during his arrest. Although the case registered against him and the co-accused was under 21 small a of the NDPS Act. As such, the petitioner on interim is enlarged on bail. Whether you have prayed for that?
No, you're not.
Feed by this court. Okay. Clever interim. Yes. And then what? May be released in interim. The petitioner may be released on bail on furnishing of a bail bond of rupees 20,000 with 2 local sureties. Okay, with 2 local sureties. To the satisfaction. With 2 local sureties of the like amount to the satisfaction of the
Investigation.
what is this called?
NDPS code 0.
Special court NDPS.
Satisfaction of the Special Judge NDPS 0 Arunachal Pradesh with the following conditions. Okay. Call for the case diary.
Lord-
mm,
Your Lordship is,
the matter to be listed after 3 weeks.
Your Lordship is passing an interim for the bail, Your Lordship, since Your Lordship, though has rightly pointed out that their interim seems to be in a very sharp manner, Your Lordship. However, Your Lordship will see that this is a criminal revision, Your Lordship, and the only challenge is with regard to the rejection of the bail, Your Lordship. In that case, Your
So
Lordship,
that will have to be suspended.
only suspend of this. Your Lordship.
In the interim, the order dated 19/6/2025 is suspended till the returnable date. Further, in the interim, the petitioner may be released on that bail part. And more.
Bail part, Your Lordship. I was just coming to that, Your Lordship. Since the only prayer is only challenge made in the cause title is with regard to his this order, Your Lordship. Has not
allowing him.
approved. Yes, he's not
But
approved.
in the main prayer, he has also reflected for bail and all. He has also prayed for bail in the main prayer.
Yes, sir. Because there is no bar upon him to come before this court for a bail, Your Lordship, even though this has been rejected.
But then suspending only this
Yes. They,
will
in
not
fact,
give him full.
in fact-
will not give him relief for the time being.
yes. In fact, on the earlier occasion, they have come before this court on bail application, Your Lordship.
Acha.
They have withdrawn it, and then this revision was filed only for challenge of it. He has a
Oh, yes,
full
I
right.
remember he
Yes.
withdrew,
Yes.
but I did not see the petition that time.
Yes, Your Lordship.
But then only suspending this order
Yes, Your Lordship.
will not suffice as far as he is concerned. So
Yes,
till the
eh,
next returnable date, let him be on bail.
Yes, Your Lordship.
Highly obliged.
Deeply approved. After 3 weeks, after 3 weeks, give a date in the month of August. 7th of August. List the matter on 7th of August 20.
Meanwhile, Your Lordship may call for the CD, Your Lordship. Yes.
Deeply approved.
May I?
Just a second. After this, most of all, wait a minute. So that is. Contract will be actually taken, given reference. Yes.
May Lordship, I filed a quashing petition under 528 of
Washing of the FIR
Yes, quashing FIR along with the charges.
and the criminal proceeding.
Yes, both are the petitioner number 1 and the petitioner number 2 are both are the siblings. Only on
Both
the
are?
both are the siblings,
Oh, brothers.
brother and sister.
Oh, brother and sister. Okay.
Only the miscommunication is that the petitioner number 2, who is the brother of the petitioner number 1,
Settlement.
yes, already settled. And moreover, the sections are also compoundable in section.
Oh, sections are also?
Yes, compoundable.
the section.
What sections?
Compoundable.
Compoundable.
Yes.
Then you can go towards the law, not required before the High Court.
No, there is some technical issue. That's why.
What
I
technical? If it is compoundable, they will do it.
Lordship, the petitioner number 1, petitioner number 2 is going to contract in the market welfare association. So the petitioner number 2, who is the brother of the petitioner number 2, is going to contest in the Bazaar Welfare Association. So
Some
for that,
election.
For that, he needs NOC from the Honorable Court.
No, for that you cannot move such petitions here. You move it before the lower court. It's compoundable offense. How can I entertain?
Yes,
This is not maintainable before the High Court. You withdraw this, file it before them.
yes,
And if they disagree, then come. The petitioner prays for withdrawal of this application to file an appropriate application before the appropriate court of law. Prayer is allowed. Matter is dismissed as disposed of as withdrawal. Read there.
Hello.
If something happens, then
My lord, this item number 6 and similar, my lord, is arising out of same, my lord. My lord, yes, my lord. My lord, for convenience, my this matter be taken, 6, 7 may be taken up, my lord. It's same matter, for convenience, 7, item number 7.
this is for what? Quashing of FIR?
Quashing of charge sheet as well entire proceeding, my lord. On the
Oh.
ground that, my lord, this charge sheet, my lord, this arising out of FIR dated 8 January 2025, my lord. Here in this case, my lord, on receipt of this FIR, the allegation is that petitioners are member of National Socialist Council of Tani Land. One
Sorcery. What?
National Socialist Council of Tani Land. They are member, they are associated with that member,
What
my
is
lord.
sorcery?
Socialist, Nationalist Socialist Council, my lord. It's unlawful, under unlawful association, unlawful, my lord.
This is
Now,
unlawful.
yes, that in on the basis of the base.
Socialist.
Yes, madam.
Okay.
On the basis of
National Socialist Council.
yes,
Okay.
on the basis of this FIR, my lord, the waging war section 147, 149, 50 BNS raid with 13 of Unlawful Activity Prevention Act 1967 was registered, my lord.
13 was raising money.
No, my lord.
Section 13 was what?
13 is whosoever involved in those illegal activities, my lord. Unlawful
Terrorist
activities.
activity.
Yes, my lord. Kind of terrorist, my lord. That is matter. Now, under this, my lord, having investigated this matter, my lord, charge sheet number 73 of 2025 was filed on 23 April 2025, my lord. My lord, here, under this provision, my lord, whenever section 3 is section 13 of Unlawful Activity Prevention Act
Give me
is
that
invoked.
UAPA Act. UAPA Act is there. Perhaps it's there. Unlawful Activities Prevention Act. They see in you. And where is the charge sheet?
My lord, charge sheet is at page 55 onward, 25 onward, my lord. It's very simple, my lord, just in nutshell, my lord. My lord, under this, my lord, charge sheet before filing charge, since section 13 is there, section 13 of Unlawful Prevention Act is there, my lord. Section 13 falls under chapter 3 of Unlawful Activity Prevention Act. Now, when the section 13 is involved, is booked, my lord, is charged, my lord, then requirement of statutory requirement under section 45 follows, my lord. Under section 45 follow as per under section 45, my lord.
45 D5.
Yes, section 45 of Unlawful Prevention Act, my lord. It says that after investigation, investigating officer has to forward the whatever material evidence they have collected to the independent body, my lord, to be constituted by the government, central government or state government. Now, that independent authority will review the entire material collected during the investigation, so as to obtain the sanction. If they find that if they convince that this can be recommended for the authority government for obtaining sanction, then independent authority they recommends on receipt of this investigating material, that recommends to the authority within 7 days. On receipt of 7 days, the competent authority government will grant a sanction under section 25, section 45 of subsection 2, Now,
You're referring to 45 or 43?
yes, 45, man.
45.
Now, 45, my lord, and this man, without compliance with this, my lord, The court cannot take cognizance, my lord. Here in this unfortunate matter, the cognizance has been taken, even the investigation, the whatever material they have collected in the charge sheet that has not been reviewed by the independent body, and neither independent body has been constituted, nor they have obtained sanction, my lord.
Where is that provision, independent body?
Yes, my lord. I'll just section for the convent, my lord, section 45 of UAPA Act, my lord.
Yes.
My lord, let's start from 1, my lord. 45.1. No court shall take cognizance of the offense. 1. Under Chapter 3, without previous sanction of the central government or any officer authorized by the central government in this behalf. Now, Section 13 falls under Chapter 3.
For 13 is Chapter 3.
Yes, ma'am.
Just let me have a look. 13.
It's under Chapter 3.
Punishment. Chapter 3.
10 to
What
14
is
is
it?
under Chapter 3, ma'am.
Section 3 is abates, advise, incites commission of any.
Section 13, ma'am. It
Okay.
falls after Chapter 13, Chapter 3. The Section 10 to 14 is falls under Chapter 3.
Without a previous
Yes.
sanction of the central government.
Yes, my lord. Now, the next, my lord, for the subsection 2, my lord. Sanction for prosecution under subsection 1 shall be given within such time as may be prescribed, only after considering the report of such authority appointed by the central government, or as the case may be, the state government, which shall make the independent review of the evidence gathered in the course of investigation and make recommendation within such time as may be prescribed to the central government, or as the case may be, the state government. Here, my lord, in this case, no section, no independent body was constituted, nor it has evidence gathered during the investigation has been reviewed by the independent body. No sanction was obtained. And despite in absence of this all, my lord, the cognizance was taken by the trial court, my lord. Now, with regard to the subsection 2, my lord, time limit, it has been prescribed in the rules, my lord. Unlawful activities, prevention, recommendation, and sanction prosecution rule 2008, my lord.
Wait.
My lord, page
Yes,
38 will see, my
I've
lord.
got it. Then.
My lord, rule 3, my lord. Time limit for making recommendation by the authority. The authority shall, under subsection 2, that is independent, my lord, 45 of the Act, make it reports containing recommendation to central government, or as the case may be, the state government, within 7 days of working days of the receipt of evidence gathered by the investigating officer under the court. Now, next, my lord, after reviewing by the independent, my lord, time limit for granting prosecution, rule 4, time limit for sanction for prosecution. Central government, or as the case may be, the state government shall, under subsection 2 of section 45 of the Act, take a decision regarding sanction for prosecution within 7 working days after received recommendation of court. Now, here in this, this whole entire provision has been flouted, madam. There has not been adhered to, has been violated. In violation of this statutory mandatory provision, madam, the charge sheet has been filed, and it is invalid charge sheet, madam. And on the basis of this invalid,
There is no impediment for filing charge sheet. Only cognizance will not be taken.
No, madam. For a filing charge sheet, before filing charge sheet, they have to, the charge sheet, whatever the material they've collected, has to be reviewed by the independent body as per the section 45 subsection 2, madam.
They will.
They have not done.
Only for the purpose of sanction.
Yes, but they have not done it, madam.
I mean, before cognizance.
Yes, before cognizance.
Charge sheet, you leave it.
Yes.
Before cognizance, they did not.
Yes. Before cognizance taken, the whatever material they have collected during the investigation, this has to be evaluated, examined by the independent body, madam. Section 45, subsection 2, madam. Then they will recommend, after having scrutinized the detail.
This is the internal procedure.
Yes, ma'am.
We will have to see whether cognizance is taken
Yes.
with sanction or
Yes.
without sanction.
Madam, my irrespective submission, madam, I've stated that this has no sanction has been granted. Now, without any sanction, madam, this cognizance is taken, madam. Madam, cognizance part at 143, madam. Cognizance was taken on 20th April 2025, page 143.
Yes.
My lord, this is the my lord.
I
Even
have carefully produced the charge sheet, witnesses, Caesar memo, disclosure. There are sufficient material for proceeding according the cognizance is taken. Since the period and the next production of so and so, okay. They do not
And-
speak about sanction.
yeah, for my lord, there in the top they have mentioned my lord. Now so far for taking this cognizance, my lord, the sanction is mandatory, my lord. Without sanctioning, without obtaining sanction, this cognizance is taken, which is barred under subsection 1.
Cognizance can be taken even during the proceeding, during the trial. But if you can show that cognizance is not required. Here, of course, nothing has been done.
My lord, yes, but my lord, you see section 45, my lord, subsection 1, no cognizance will be taken, my lord, unless the sanction is granted by the central government or as or state government or authorized by the central government.
That is okay. That is in respect of 197 PC Act, everything.
My lord.
So here what I mean to say is, yes, sanction is required.
Yes.
And if it is shown that sanction may not be required, it may not be in discharge of duty, oh, that 197 will not come. But sanction can be taken even during the trial.
My lord, that cannot be. Because this is mandatory, my lord. That has to be done before time limit, 7 days time limit is there, my lord.
Okay, go
Af-
ahead. Then after that, this
After
is the
the-
point.
My lord, this is the point. This is the crux of the point that I've raised. Because since there's a defect in investigation and the cognizance was taken despite
Without
the
sanction.
statutory restriction, my lord. That is why, my lord, that the cognizance taken by the trial court is paid in law, my lord.
So you have challenged it.
Yes, my lord.
Today, this is the first time.
Yes, my lord.
So what do you say, Mr. Ete?
Yes, my lord. At the outset, Your Lordship, I will come to the merit also, not on the maintainability only, Your Lordship.
Oh, did you finish or you have something more?
My lord, that part, my lord, some
Reply.
substance, my lord.
Okay, then yes. Yes.
My lord, they have in fact challenged the cognizance order. So now, Your Lordship, the merit part will come later, Your Lordship. The part on maintainability, it's an intermediate order, my lord. So once it is an intermediate order, revision lies, not 482. So I have the judgment on that, my lord. And second part, when revision lies, the person who is aggrieved, that must be implemented as a party. So here, one of the victim name is mentioned in the FIR Hatatu. He has been threatened by this so-called self-style association. So he has to be implemented. And Your Lordship, since it is an interlocutory application, it's an intermediate order, because reversal of the impugn order will result in culmination of proceedings. So it will be have a flavor of intermediate order. So revision lies, not the criminal petition.
This is 482.
Yes, my lord. 528 corresponding.
And if you have other course of law that you have revision power, then you should not come under actually this 482.
My lord, so far cognizance part concerned, my lord. It is-
Let him finish.
Yes,
Let
yes,
him finish.
yes.
Let him finish.
And my lord, the offense committed by him, alleged to be committed, is under section 147, 149, 150 of BNS, is also there. And Arms Act also. So now, Your Lordship, it is well settled. Actually, the assuming that the sanction has not been taken for this offense only. No doubt, if cognizance is not there, the trial court cannot proceed with this offense. But for the other offense, the trial court can proceed. For that, sanction is not required.
Like in PC Act. we
Yes,
find
exactly.
that-
It's identical, my lord.
No, PC Act, it is said that if there are analogous offenses, then the court will try.
Yes.
That is not there, I think, UAP.
Yes, Your Lordship. Your Lordship, it's an identical to section 19 of the PC Act. His Lordship, recently, Your Lordship, the Honorable Supreme Court has, Your Lordship, because it's a matter of sanction, Your Lordship. Different law, the law is same only, similar only. There, Your Lordship, for PC Act, the sanction was not accorded by the government. But, Your Lordship, for the IPC sections, 197 law comes. 197, Your Lordship, is not a fundamental necessity for cognizance. It can be considered on the later stage. So now, if we see section 45, it's an identical to section 19, for which for cognizance is a fundamental requirement. If not taken into consideration, then the proceeding has to be dropped. It will not amounting to acquittal. It's amounting to discharge for the time being until unless the sanction is accordingly accorded, my lord. So now, first line of argument, my lord, on maintainability. Second on, Your Lordship, the sanction part. There is a two part in the sanction. Interestingly, Your Lordship, the first part says the sanction is required. The second part explain how sanction has to be accorded. Firstly, they are saying the sanction is not been accorded. The second part will come later, not now. If sanction is accorded, that is a matter to be considered during the trial, whether the proper procedure has been followed or not.
Yes.
They cannot simply come and say it is not done within this time and all, because there are certain, your lordship, situation and circumstances where the authority may not be in the position to take sanction within the time frame. So these are
That ground he has not taken.
no. The second part is
placed.
yes,
And
yes.
he said that only on non-receipt of sanction. Yes. You had placed that 7 days time in the procedure.
My lord, this is a mandatory, my lord, that has been settled, my lord. That's a mandatory.
That ground also you have challenged.
My lord, yes, I have challenged that part. Because that is mandate that cannot be enlarged, my lord. That is statutory provision, my lord.
Different issue. Yes. Then
Yes, the part for my lord, it says for chapter 3. No doubt section 13 fall under chapter 3, my lord. For that, the sanction under subsection 1 clause I is required. It's mandatory. But the second part, my lord, whether it has been done, as your lordship has pointed out, it's an administrative part. It's not a judicial part. They will say it's not necessary the charge sheet has to be, original has to be sent or placed before the concerned authority. They may have sent the certified copy. These are matter which has to be considered later on. Now, if they say the sanction is not accorded, now the court has to decide without this sanction, the court can proceed further or not. Now, if assuming the sanction is not there, my lord, because this is for the motion, I don't have the record now. If assuming the sanction is not accorded, but only for the UAPA Act, the court cannot take cognizance. But for the other offense, it can proceed further. Because for that sanction is not required. And Arms Act also, your lordship, I have the instruction that for Arms Act, the sanction is there and they are not on that, your lordship. So, your lordship, at this stage, your lordship, notice may be issued, and your lord, notice may not be issued, your lordship. Sorry, I'm promising because I am raising issue on maintainability, your lordship. Maintainability issue may be decided first, because if it is found not maintainable, then they have to, your lordship, file with the appropriate application, and implement of this person, your lordship, may kindly come to the FIR, your lordship.
yes, page 24, I think.
Yes, my lord, 24, your lordship. Your lordship will see the point 5, your lordship. The allegation point 5. Additionally, Anthony Doke is accused, and the NSCT have issued threat to several individuals, including Ha Tatu, named, your lordship. Others, if it is not named, it's okay, fine, for this moment.
Yes.
Warning of dire consequences if their demand are not made, a copy of so and so. So this person is a necessary party, my lord. If this order is interfered, then, your lordship, it will cause prejudice to this person if opportunity of hearing is not been afforded, your lordship. So he should be impleaded, my lord.
No, the threatening was given. What additionally, Anthony Doak and NSCT have issued threats to several individuals.
Yes, but he is named here, my lord.
And Ha Tatu and others, warning of dire consequences if the demands are not. No, that is, he is not the necessary party here. Some threatenings were given to some third person.
My lord, the FIR is actually, your lordship,
The
lodged.
informant, the one who has informed, that is Kengo Dirchi.
He is the
He is
DSP, my
police
lord.
officer.
Yes, my lord.
He's the
DSP.
party, my lord. Complainant, he's the party, my lord. He's party here.
Party, that is enough. I don't think so. This one, to whom the warning and the threatening is given, are required to be party. We need not hear everyone, whoever receives threats and all. But on that maintainability,
Yes,
on
Your Lord.
revision, this is important.
My lord,
There are so many decisions that if
Yes.
revision lies, then one
Yes,
cannot come
absolutely,
under
yes, Your
42.
Lordship.
So show me one decision then on maintainability, what you say.
my lord, maintainability is so far the cognizance part when there's a bar, my lord. This, the even Bhajan Lal, my lord. It is,
This is different. I'm talking about maintainability because you are coming against the cognizance order, which you
Yes.
say is wrong. And cognizance order is an intermediary order. For that, revision will lie.
my lord, cognizance order, my lord. It is the cognizance is part of the complete. There will be no two cognizance, my lord. Cognizance order once is taken, it is.
I'm on the preliminary issue on
My lord,
maintainability.
my lord.
Cognizance under IPC, cognizance
My lord,
under UAPA, I'm
the
not
once
talking.
cognizance taken, my lord, when it is restricted, it is barred that you cannot take cognizance. But cognizance is taken, the once cognizance taken, that cannot be, my lord, taken twice, my lord. That's that part of the cognizance
Yes,
become
that is,
complete.
that
my lord.
is on your
That is-
cognizance. But
yes.
what about maintainability?
Maintainability. That's why, my lord, there's an abuse of process of law that is maintainable under section,
Revisional power.
my lord.
When you have revisional power, only when you are not with any remedies, you are left with no other remedies. and there is an abuse, then you can come under 482. But here you have a recourse, you have a law, you have a window, you have the revisional power. Then, of course, one thing can be done. This can be considered as a revisional application. That sometimes is done.
Your Lordship, under revisional power, the court can convert it, but not under 482.
Then those things will come.
And your Lordship, limitation also comes when revision comes. This aspect has to be taken into consideration.
Yes, limitation. When is the order passed? Cognizance order?
Cognizance, 143, my lord. It was taken on
28/4/2025.
my lord.
So I think you have 90 days or 60 days.
90 days, madam.
90 days.
Yes.
So 5, 6, 7. You may still have time. Why don't you withdraw it and file a revision petition? Because you see, you will be confronted with the laws that only in exceptional circumstances 482. And then your petition will go on maintainability. Better you withdraw, file a petition under revision.
My lord, in my respectful submission,
That,
In
what is
such-
the difficulty in doing? You just have to change the first title.
my lord,
And of course, the rest of the requirements will come. Rest of the.
my lord, that part is there, my lord. So far, my lord, since it is when there's a abuse, when there's the bar under law, my lord, that is in that case, my lord, when the authority have not exceeded within the jurisdiction, if they exercise the power, then revision lies, man. When the authority, the learned trial court exceed the jurisdiction, having no jurisdiction, then ultimate the remedy is before the criminal petition matter, inherent power matter, because this is the case which has been exercised beyond jurisdiction matter. It's not within jurisdiction. I understand that can be reviewed, but this is the case
This
of
is a law point which he has not followed. He
But-
had taken cognizance without sanction.
yes, that is beyond
So-
jurisdiction matter, beyond authority of law.
This is what is beyond authority. And when you have power under 401 and 397, why this inherent power?
Inherent power matter because
Why don't you just withdraw and file a revision petition?
my lord, in my respect to Sami, then it is the because in the revision lies, my lord, when there's no abuse of process within the jurisdiction, but this is not a case, my lord.
Okay, he's not agreeing. Well, what? You have raised a maintainability point. We will hear on the maintainability.
Yes, absolutely.
Let him
You
let
fix
him
it.
go through.
Yes, then fix it,
You
then,
do
madam.
one thing, mister.
My lord,
you do
we'll
one
make
thing.
in that case, my lord,
No.
we'll make correction, my lord.
No. Or you prepare on the maintainability point. Next day we will hear. Maintainability on and go through the judgments and all.
My lord, in that case, my lord, I'll take
No, go through.
unnecessary, my
No,
lord,
better you go through.
my lord,
Whether revision lies against disorder, you also go through.
my lord.
Right? You go through whether revision lies against disorder. If it is an interlocutory order, then revision will not lie.
Ah.
If it's an interlocutory order, not an intermediary. So many suggestions from.
My lord, all right, sorry, thank God. So many things, my
What I'm
friends.
saying is,
All right, man,
interlocutory order.
my lord,
So go through.
my lord,
If it is an interlocutory, no revision. If it is an intermediary,
my lord.
it seems to be an intermediary
my
because
lord.
it has established some rights. Okay. So go through on the maintainability issue and come back.
My lord, in that case, let us, my lord, I may be allowed to take a press my lord, on revision. my lord.
Not required. You go through. For the ends of justice, I'm saying you go through. Whether it's an interlocutory or an intermediary. Because this point is very new that Supreme Court has come with. Intermediary. When we studied, we did not have this.
My
This
lord.
is a new concept. So go through whether revision lies, and if the revision does not lie, then so this will apply. This will
Well.
be the application. Okay.
Well.
Heard Mr. So-and-so, NT.
My lord, can it be listed tomorrow, my lord?
Not tomorrow. Tomorrow I have a partnered matter. It will be listed immediately after vacation, 21st or 22nd of July. You'll have to go through many decisions, mister.
My lord, in that case, it will be when it take it may break the matter, my lord. In that case, to cover up all, my lord, I may be allowed to withdraw and will take appropriate course, my lord.
But CD law.
My lord, I'll take that's why, my lord. Because in case if it's posted, my lord, again, that our time is running. That's why, my lord, for safer side, we'll do it. And will be allowed to withdraw with fresh, my lord, to file, liberty to file fresh, my lord.
Okay,
In
you
accordance
have
with-
Mr. So-and-so and Mr. So-and-so, and Mr. So-and-so prays that the instant petition, he may be allowed to withdraw the present criminal petition and file an appropriate application under the appropriate provision of law. Prayer is allowed. The matter is disposed of as withdrawn.
With liberty.
With the liberty. Oh, yes, I've already given.
6, 7, my lord, same.
Huh?
Same.
Same.
6, 7, same.
Or same also,
Yeah.
same with 7 also.
Deeply obliged.
But bring judgments on revision, huh?
My lord, that's part.
Okay. This is the Pathar matter. Yes, yes. I heard to some extent, right, that day?
My lord. My lord, so far this item number
Maybe it
11.
is discharged, I think.
My lord,
Maybe it is discharged.
before
Yes.
my train start, my lord, I'm not stopping him from the hearing. This is a part of matter, my lord. Here in this matter, my lord, 2 days before we have been engaged by respondent number 1 and 2.
Mm.
That is my friend complete. We may be allow some accommodation so that we
No
can.
accommodation, I'll be leaving on Friday.
My lord,
Friday.
in this matter, my lord, Learned Senior Counsel, Dilip Majumdar is arguing. Right.
He can do it
went to,
online also.
he will do it online. He's in Siliguri.
He can do it tomorrow
Tomorrow,
or today in the second half.
my lord, actually, there are some pages are also missing, my lord. More than,
This
So-
you should have said in the beginning,
no.
because
oh,
otherwise
no,
I made it
lordship,
partnered.
That's why, my lord, there is a part of matter. That's why we have not mentioned.
No, before, on the first day only, you could have said. Or he
No,
was
that
there,
day
he
too,
could
I
have said
don't know,
some
my lord.
pages.
My friend
That
was
day
there.
we have not gone and checked through the entire pages. So today when
This is subsequent.
no, no,
No,
honestly, we are saying, and this type of
more
petition
than 10 pages are not here. In
with the
this
missing pages, they should have served with us.
And
Yesterday, I have
informed-
gone through everything, my lord.
my lord.
Yeah,
this
very
is-
lately you have gone through. I've
Yes, my
already
lord.
made partnered.
And my lord.
Lately, we have been
This is-
engaged.
They have already made notes.
And this is, my lord, not something, this entire documents is the lower court documents only, my lord.
Mm.
This is not
Yes.
something the first time I am using here. All the documents we have used before the learned trial court,
Mm.
all documents he has, every documents he has.
Not a very
So,
complicated
this
matter
is-
also,
and-
election matter.
Yes, my lord. And issue, my lord is sitting in the principle as a appeal. My lord will only consider whether grant of injunction in
Mm.
such cases, whether it's a reasonable,
Mm.
arbitrary,
Mm.
or capricious or principle laws. That is only my lord will look into. Not in the entire matter, even not required
Yes.
to look into. My lord.
Continue, it's okay.
My lord.
You are there, you can.
And
Now
this is
continue.
this is only my lord,
The
nothing my lord.
clients
Let
expect
me-
that, my
let
lord,
me-
learned senior
I-
counsel may argue.
I understand, my lord. Only
My
the
lord,
only
let him-
purpose is to avoid this
No,
bench.
no, 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 no.
And since matter has been part had,
This is
and
not a way.
it's so
No,
it's
had
so
it not
apparent.
made partner, then the matter would have.
No,
been-
my lord, but I,
It is so apparent. I think I do not
My
need
lord,
to
That
even
cannot be
say
there.
it. So
Judgment is
apparent.
one. Why will
lordship,
someone?
what my humble
Ah.
prayer is before your lordship. Let my friend complete his argument. Let us give us a chance, accommodation, so that we can also reply his argument.
No, but then that will, cannot be
No,
too
we can
far.
do it so BC also.
No, you have
At
to either
principal-
do it today afternoon or tomorrow morning half.
No, we will do it in the principal bonds also, my lord. There's
Principal
been
says
no-
next to next week, I'm in Kohima. Cannot.
We can do it BC, my lord.
No,
Because
that,
he-
you could have made this.
Because of his
And,
difficult,
and my lord,
my lord, he went to, my lord, Siliguri. He's coming.
No, I understand.
That's it.
Mr. Majumdar will do the matter, but then you should have pointed it out before. This is, I
That
made
too,
partner, I would
yes,
have
my
made
lord.
otherwise.
That
I would have
was-
postponed it.
I am sorry for that, my lord, because we also don't know.
this is all the because of the earlier counsel. He was ready to argue all the case.
matter part heard,
No.
then suddenly he has
New
engaged
part,
someone
engaging.
else now getting
No,
the matter at.
let us
This is
continue.
very
Let us
clear.
continue.
It's so apparent.
No, let us
So I will continue with my argument.
And
So
then
let them do whatever they do.
In the meantime, you hear and then you submit.
Yes.
Okay, you were on what point?
My lord, almost relevant facts I have covered.
Hmm.
All the facts. So far, this.
He has made substantial arguments.
my lord. Item
This is
number
not done at this stage.
Item number 8 is concerned, my lord.
No,
Item number
let
8
him
is.
complain, no problem, my lord.
Yes.
I am
But
not
then I will
explaining.
finish it by tomorrow.
My lord, item
Because
number.
I'll not be here. I'm going Kohima, then Mizoram. I'll not be available. I made it part.
May-
I'll have to release them.
May I please, Lordship?
Ah.
In this case, Lordship, only some part it was heard last time. Thereafter, this is the client who want to engage the
You
senior
should have
counsel.
That day.
No, Lordship. That day I was there, but the later on client said they want to engage senior counsel. So I do not have objection. They have filed Bakalat Nama this morning. And
So
when
very
we
late.
have
That is what.
kindly, Lordship. Thereafter, when we were delivering them the briefs, when we got it Xerox, we found so many pages missing, honestly. And we informed the junior also, his junior also, that such pages are missing. Immediately you provide us. But then,
For tomorrow, first half, tell Mr. Mojumdar to do by online. Okay, first half as first item.
First
You can finish it.
My
today.
lord.
Okay.
Well, I will finish.
Subject to my lord, this one. They may furnish us the copies.
Yes,
my lord.
all the pages, missing pages.
I will provide my copy. Just now, I don't. I will get new copy. My lord, that may be recorded. Again, they will say copy not furnished. My lord, all the relevance facts I have covered.
You have covered the facts.
Facts, my lord.
But you have not stated about the ground.
Grounds. Now I will come. This item number 8, my lord. This item number 8 and 11. 11. Both are related matter, but some facts are different, my lord. So item number 8, my lord.
Hmm.
Now, what are the grounds on which
Item
basis?
8 means FAO 5.
Five, my lord. Now, first ground is, my lord,
Hmm.
on the ground of maintainability, my lord.
Hmm.
My lord, here is the case, more than 1074 delegates, they got involved. Under the constitution of the union, my lord, the students who are who hail from the district of Kurungkame, they are the members. Altogether, 1074, they got involved.
1000.
1074
Oh, yes.
voters, delegates.
Hmm.
Now, in their pledge,
Hmm.
neither this union
Hmm.
has been implemented in a representative capacity. So this 1074 who are definitely is affected
Hmm.
because it is their representative body
Hmm.
who has been stayed and who has been restrained from functioning.
So non-joinder.
Yeah,
Hmm.
for non-gender of the necessary party,
Hmm.
this is on maintainability.
Hmm.
Now, second on maintainability, basically, my lord, this is a internal matter of a voluntary association.
Hmm.
This is not something statutory body
Hmm.
or something like that. This is completely a voluntary association. Even it is not a registered society, my lord.
Hmm.
So it has its own constitution, its own bylaw. So the settled legal position is led in such situation when the voluntary association, judicial interference should be very limited because this is the internal matter of a voluntary association. The most what that they have right is of the contractual right arising of the voluntary association. Now here, the APSU, which is the central body,
Hmm.
APSU has approved, recognized, and APSU being a parent body has validated our election. And once, my lord, APSU has recognized, because it is the APSU who has a control and supervising all the
So where is the document where APSU has recognized
My
the
lord, my
election?
lord. Yes, in that I have some today also. I will show, my lord, that part, my lord. I will show.
Yeah, I remember you had shown. I just want
My
to
lord,
see it again.
I will show. I will show again.
It's okay.
My lord.
You continue with your.
Yes. Now, second point on locus standi, my lord.
So, sir, the maintainability, you say that this is a voluntary organization and court should not interfere.
My lord, internal matters, all those things, my lord. And one more point.
Title, so.
On one more point, APSU has already, the parent body who has a control supervision has already recognized. So what they should have done, because it is a parent body, if anything, if election, now their allegation is that no election was held. They should have raised the issue before the central body who will see whether these things happen or not. Thereafter, they will take the decision. So this apart from this non-gender of the necessary party, 1007. Now, my lord, locus standi. This is very important. Now, what is their plaint? What they are saying? They are saying their case is not like that they were not allowed to contest the election.
That is.
First point. Now, what is their case? Well, they did not have the right to vote. Now, question comes very interesting. When there is no rival contender, my lord, where is the question of voting? Is there any plaint in there? Is like saying that other rival contenders, they are not before my lord. We're saying that we wanted to contest the election. We were deprived. So allow me the chance, then matter would have been different. Now, here two persons, my lord, who filed the nomination, who got themselves enrolled in as a candidate, when no rival candidate was forthcoming, they have been declared contested. Now, my lord, in such circumstances, I don't understand how any right is infringed. Now, this plaint has been drafted in such a manner, saying that we are espousing the cause of all the student body. Is it PI, my lord? It is not PI. Now, the plaintiff has to show his infringement of his individual right only. The entire body is not there. But what the learned trial court has said. Now, what is their prayer? Is not to allow to contest. Now, they don't need to contest even. They have been declared elected. Now, for example,
What is their prayer in plaintiff? To conduct election.
To declare our entire result of the entire selection body and to conduct election. Do they have their right? Question number one. From where they got that right? Their right to first right is to contest, not deny, not contest. They have been selected even. Now the question comes: if they don't want this post, which is still lying vacant, who is preventing? Definitely, fresh election will be held for these two posts. But how they have locus standi to challenge the other elected executive body to which post they are not even contesting? How they have that locus standi? Well, as much as 29 executive bodies are there. Now, this 2% plaintiff is only for the post of Assistant General Secretary and Assistant Education Secretary, these two posts. Now, my lord, suppose this 2% is saying, since no election was held, we want re-election, we don't want this post. Okay, these two posts is still vacant. Definitely re-election will help. You contest there. If you are such a genuine person who thinks, my lord, that unless any rival body doesn't come, I will not take the post, well and good. And we don't know tomorrow if a fresh election takes place, anybody will contest or not. So what the plaintiff is saying, until and unless rival contenders doesn't contest with me, I will not take the post. I think this is something has taken a very high moral ground, which is beyond the understanding of the reason. And I will also show why they throw, because behind them is the plaintiff in this item number 11. They are only the stooge. They are being used by the plaintiff in another that FAO. I will disclose how their connection is there. Now, initially they were with us. So later on, what happened? Completely taken a different step. Now, my lord, they enrolled themselves in this thing candidate. They got selection, everything till the time. So what happened basically, my lord, as a matter of fact, we filed a caveat petition. We never anticipated that this person would file the case. We filed the caveat petition in the name of the plaintiff in title number 7, which is the item number 11. My lord.
So your caveat, the prospective plaintiffs were different.
Item number 11, madam. Because they were interested for contesting for the post of president and general secretary. So when they came to know that prospective petitioner they have been met, they managed them. They put there and they got the
Oh,
ad interim
that
injunction
is
order.
what you want to.
Yes, yes, this is the real fact. But
But then that means there were contestants for the post of president and so and so.
in other case, my lord,
Huh.
this
Election is same.
my lord, election is same. I will come to that. Item number 11, my lord.
Uh-huh,
Now, now they are saying that they wanted, of course, initially, the plaintiff in item number 11 wanted to contest. He even participated in the meeting also, wanted to, but what prevented him from filing the nomination, that we do not know. Because, my lord, it is not the duty of the election commission to go behind each candidate asking you contest. I will sit there. If anybody files nomination within the time, I have to do as per. If no nomination is filed,
So he did not file nomination.
nomination did not file, and even he did not get himself enrolled in the candidate. But he had expressed his intention to contest. That's why he had raised so many objections during the process, and that was amicably settled. So many meetings happened, so many demands made by the plaintiff were fully addressed, and after that, there's a sequence. Now, but what happened? The fallacy of the plaintiff in this case, they thought that unless prospective petitioner is identified, there is no value of caveat. What's their main intention was. But law is not like that. Law says that you may say prospective petitioner, but doesn't mean that if anybody files, caveat should not be given. It is not like that. You may identify prospective petitioner, but you cannot say that because this order will be put to challenge by whom. So the law says that whoever may be, either even the caveat is not filed by the prospective petitioner, even then, or sometimes you may not be able to identify the prospective petitioner, even then when the caveat is filed, then notice has to be given, hearing has to be.
Yeah, you have some judgments for that.
Yes, my lord, I have judgment, my lord.
Otherwise, let us see that caveat, what provision? CPC? I think, what, 48? 148A. 148A, I don't think so. I mean, I forgot what was the language? Wait, 148, I'll read out for you. Yes. When an application is expected to be made or has been made in a suit or proceeding instituted
My lord.
or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat. Okay. 2 will be important. Where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged shall serve a notice of the caveat by registered post acknowledgement due on the person by whom the application has been made or is expected to be made.
My lord.
So these are the 2 prospective petitioners.
My lord.
Where after a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of application on the caveator.
Right.
So, of course, in 3, he did not say any application filed by the prospective
No,
the petitioner's name,
not-
it was not said.
not.
Any application filed in the suit.
Yes, yes. And this has been interpreted and dealt with issue also because issue has raised and says that, my lord, anyone. Suppose sometime even it says that caveat, even it is manageable. If suppose some order is there and you're not sure that who is going to file that case. Even in this situation, you can lodge the caveat, and in this situation, if anybody files the suit or any case, my lord, then notice is to be there, my lord. This is there, my lord. I will provide judgment, my lord, in that regard. Now, my lord, now, my lord, this plaintiff's voluntary participation and acceptance of their position is evidenced by their signature on the enrollment list of candidates.
Okay.
Once you have, because that shows that you participated in the process, my lord. Now, their name appears as serial number 10 and 20 of the.
We have shown
My lord.
10 and 15.
Yes,
I think.
my lord.
Or,
Now, now, very interesting, repeatedly in the plain, what they are saying that no voting took place, no voting took place. My lord. Question remains, my lord, when there is no rival contender, question of taking vote doesn't arise at all.
I think there is a recent case before the Supreme Court
My lord.
on no voting.
My lord.
I got it in live law.
My lord.
But then it's not finalized.
My lord.
Matter is pending.
My lord.
That whether, where is the RP Act? Whether no voting
My lord.
in a case where there is no opposition
My lord.
is legal or not.
Right.
You can check that. There is it's pending and it says it's likely to be listed soon.
My lord. Now, my lord, another about this locus standi is now once you have applied for the post of specific post of AGS protocol and assistant education secretary, now you don't have the legal standing to challenge the entire election result. Now, otherwise, at the most, learned trial court could have done was not to suspend the entire executive body. If they want to contest, let's assume these two persons are very great moral high person. They don't want to take without contesting this post. If they want to contest, learned trial court at the first day itself, why should we say that no election should be held for these two posts? Freely, so even this plan could have been decided in a single day, directing that okay, this 2% doesn't want to hold post without contesting. If anybody wants to contest, let the election takes place. Then after winning, whoever comes in. But how it will justify that all the posts from president to all 29 posts and you make the entire student body defunct and it's almost going to be 9 months without any representative body. My lord, it's highly unreasonable, my lord.
But no, I'm not hearing the plaint. You have to restrict yourself to the injunction part.
That's why, my lord. The unreasonable part I am showing, my lord, because my lord will be looking at it. In the nature of the case, these two plaintiffs wants to hold the election. Now the question can say they want to contest this post to which they have been elected. Now the grant of injunction is that the entire election process has been stayed. Now the question comes up, my lord, it is first, they don't have locus to challenge the entire election. Second, it is very highly unreasonable that these two persons is saying that for the two posts, why this entire selection process should be after. Now, my lord, this is the case that all the rival candidates have not filed the suit, saying that we wanted to contest all the posts so that they should not. Had it been then, my locus may not.
So he does not have the locus.
Locus, my lord. So far, these two posts, we have no problem, my lord. Let
Cannot
it be.
challenge the entire process.
Yes, my lord. This can be done. But others should not be restrained, my lord. Others should be allowed, my lord. Now, my lord, on prima facie. On prima facie case, my lord. Now, as I have said earlier, my lord, a specific infringement of right has not been disclosed. They have been allowed to participate. Their enrollment is there. In the election result also, their name is there. Now, I don't understand what right have been violated. Now, they are just making a case. Had it been the case, something like that, there were some rival candidates, then definitely matter, they would have said in a way that there were so many rivals candidates. We wanted to cast the vote and choose the election. Then matter would have been again different. There is not a whisper about that there was any rival candidate. I have given in my reply and written statement that they have not replied even, showing that any rival contender was there. Now the question is that in that situation, my lord, where is the question of violation of right? No right violated.
What is the ground taken while by the trial court that prima facie case has been established?
Prima facie case, my lord, learned trial court judgment, my lord.
Let us go to the initial
Yes,
injunction order.
my lord.
And one thing I've noticed, we have challenged only the order which has made the injunction absolute.
Yes,
You have not challenged the injunction.
but that will merge. That will merge with the my lord. That's right. My lord, this is annexure.
Yeah, I've got it. This is Annexure 6, 142.
Annexure 1, my lord, this impugn order, my lord.
No, I'm speaking about the initial order.
Initial order, my lord, yes.
Because in the impugn order, they have made it absolute.
Right.
Made it absolute on other grounds.
Yes, my lord.
Prima facie balance of convenience, those were not considered, I think.
My lord, 2 grounds, my lord. Last occasion I said.
Delay.
First 2 grounds, on 2 grounds, this has been made absolute. Initial order, my lord, will find at
142.
142, my lord. I will just highlight that. What are the grounds? Initial order. My lord, kindly start from page number 146 at the bottom, my lord.
Yes, prima facie case.
Yes.
On what ground they said?
After hearing the counsel for the petitioner, I found a prima facie case that the so-and-so was not allowed to conduct by the Deputy Commissioner Capital as well as Deputy Commissioner for Government District by prohibiting the different number so-and-so for despite prohibition order, the different number so-and-so issued another notification on that for conducting election so-and-so. From the record, there is nothing to show that the election was conducted in pursuant to the said notification issued by the different number, whether there is a cancellation of provision order passed by the Deputy Commissioner with a direction to the Superintendent of Police to execute and implement the
Achha, so no election, so he has a prima facie case.
Now, now this ground basically saying the reasoning, the learned trial court came to this reasoning that no election took place only on the ground that there was one order from the Deputy Commissioner prohibiting not to contest. In my written statement, I have brought a report that order subsequently Deputy Commissioner had revoked. And after that revocation only, that this election process initiated. That is the issue. Otherwise also, my lord, otherwise also I don't understand how the Deputy Commissioner, it is a matter of election between the, this maybe on law and order problem. That is another issue. But in my case, that has been subsequently revoked, that order. Then this ground, no more it exists. Everything is on the record, but while making absolute disorder, I have not been heard even, and these factors have not been considered. Now, second ground. She said, who have been declared as elected. Now, here also, the learned trial court ought to have considered that these 2 persons participated, enrolled themselves, and they were declared also. Now, this is not the case, my lord, where the learned trial court should take it as a PIL matter. Learned trial should have seen that what is exactly the right. In the plains, if had these 2 persons said in the plain that there were so many rival contenders wanted to contest the election did not take place, therefore we were deprived of right to choose through good, then, my lord, matter would have been different. This is not the case at all. Now, second ground, my lord. Second ground is that balance of convenience also lies with the place. Consider the impugn under the election so-and-so has not been accepted and recognized by the student body up to as of today. These are the 2 grounds only. Now, these grounds, my lord, I have, after filing my written statement, I have clarified everything. That APSU has recognized, DC has done this thing, and I have demonstrated with documentary evidence from all the issuance of the notification, everything. Now, there is no dispute so far regarding the repeated issuance of notification by the Chief Election Commission and other members of the election committee. Now, till the notification for issuance of the notification for inviting for filing nomination, everything they have admitted that we had issued. Now, only after that part they are saying that no election took place, no voting took place. But our stand is that since we did not receive nomination till 2 p.m., that's why no voting took place. That's why on the same day itself, in the absence of any rival contender, we have declared the result. Therefore, both of you have been even declared. Though one of the plaintiff had submitted nomination paper, one of the plaintiff did not, but still since he had enrolled himself in the candidate enrollment, so we thought that he intended, we gave him. So if he doesn't want to take it, we have no problem at all. He may contest for that one. We have no issue. But for others, there is no other agreed person. So far, other post is concerned before my lord. This is concerned only with 2 posts only. Now, my other grounds, my lord. My documentary evidence is on the record showing that election process was conducted. Now, my lord, there is no dispute that this election committee was appointed by the competent authority. There is no dispute. There is no dispute even that the election body was interested with the task of holding election. Once the election committee is saying that we have conducted, now who is the appropriate authority now? Whether to believe the election committee who has been interested with the task or the person who has a personal motive, who wants to have the benefit. Now, they are not saying that no election place. But the Chief Election Commission has brought on record all the nomination papers filed by the candidates.
You have shown one document where chief election has intimated saying that election was properly held and all.
Yes, yes. And immediately intimation was given to the APSU. APSU, central body, my lord. All these nomination papers have been also annexed in the document. On that day, my lord, I have shown, my lord. Now, another part, my lord, on balance of convenience, my lord.
Not accepted by the APSU.
Now, balance of convenience. Now, my lord, in my case, my lord, handing over charge, admittedly taken over. Publication was given in the newspaper. Everything was done. Now, this election executive body is for 3 years. Now 1 year is almost gone. Now, my lord, this 3 years, suppose this suit will definitely cannot be completed within the 3 years. In such case, my lord, I am the elected body. Suppose tomorrow if I win the case, then these 3 years gone. How, my lord, I can give? But so far this plaintiff is concerned, he can always contest the election, man. Tomorrow, suppose suit is decreed in his favor. There is no one. He can contest always the election. He only wants to contest the election only. But in my case, my lord, from 2 years, 1 year is already left, my lord. And this trial is not going to be fitted. And after that, my lord, if after having complied all this process, only by making a bold statement that only single statement, no election was held, is it sufficient to say that entire student body should be kept people, my lord? Otherwise, this is not about private interest only, my lord. There is 1,074% enrolled candidates. 2 or 3% are agitated. 1,070%, 4% now they are still unrepresented. Their issues are not addressed. There is nobody who can represent their issues of the entire Kurungame district. That interest also has not been seen. Even if the learned trial court doesn't want to see my interest, even then that interest have been taken into consideration, my lord. Because generally in election matter, stay is generally not given, my lord. This is the settled law, my lord. Because because interest of the larger public interest is involved, my lord. So once election result declared by the competent body, my lord, then, my lord, where is the question that now say that balance of convenience is favor and APSU has not recognized? So that federal APSU is saying in its letter that keeping them in that way, it will affect the interest of the student. That's why
so
we are
balance
allowing.
of convenience is in your side.
My favor, my lord. That pass also not given, my lord. APSU has already, my lord, by order dated 8/12/2024.
And just show me that.
Order, my lord. Page number 256, my lord.
Yes, I've marked.
And my lord, very interesting, my lord. I'll just make
No, this is will respect and honor what, this is by APSU, right?
my lord. Initially, my lord, our activities were suspended by the APSU because of the plaintiff in title number 7, which I will deal in another period. He assaulted because of whom he is
Yes,
still
you
6
said.
years ban is there, man.
You said.
Then what the plaintiff did, man, there, taking advantage of this order, plaintiff filed that title suit saying that APSU has revoked my punishment, and that's why I am filing the titles. That's my second title suit. Then we went to the APSU saying that whether you have revoked the punishment imposed upon the plaintiff. APSU has again give the clarification. This order is only for the union, Kurungkami District Student Union, for their revocation, and this order should not be misconstrued and should not be mistreated as something revoking the punishment imposed upon the plaintiff. This has made me very clear. I will show, my lord, while taking.
So that 210/24 is the punishment.
My lord.
Revoke the order.
My lord, 210/2024, that was the, my lord, there, my lord, by that order, we were also, our activities was also suspended.
Oh, achha.
And imposition of punishment was to the plaintiff also.
Then this is not, ASU has recognized. Where is the portion where they have recognized the election?
No, now the question is here. It is something like that. There is no such requirement that APSU has to recognize. APSU has, it is something like that. Our election, because once we intimated the holding of election, then that was accepted. Then until and unless APSU clearly saying that you are suspended, then it is implied that this is recognized.
Never you have to imply, but
yes, then that part also I will show by that clarification letter, my lord. That recognition part, my lord, also I will show. Now this letter is what? Our activities were suspended. Then when it has been revoked, meaning thereby that we have been allowed to work. And clarification I will show. There, APSU has said that this order, because plaintiff, this is admitted position in title suit number that APSU has revoked our and recognized us also. That is their admitted position even in the plaint of item numbers, title of suit 7. That clarification is there. Now, my lord, it is something like that. When we were elected, we intimated and we were functioning. Then APSU said that because of the assault done by those things, APSU said that we are suspending the activities. Then we did not do. Then in the meantime, they filed the suit. Subsequently, the filing of the suit, APSU has said that now we are revoking. My lord will see here the reason. Whereas it is crucial to ensure the continuity of student activism and leadership within the Kurungkami district. The reason behind, my lord, being a federal unit of APSU for the welfare and interest of the student community of the district. This is the reason why this revocation has been given, my lord. This has been made. Now, my lord, this, my lord, balance of convenience I have completed, my lord. Now I will go to the another principle on the issue of irreparable injury, my lord. Now, learned trial court is such a growing age. Just they use the word into order, growing age, UAPA. Now the question is that no finding has been made in the order. What is the upper limit for contesting the election, for filing the election? What is their age? How their growing age will be a bar for them? Another. The same thing applies to me also. I am not something very young. We are the contemporary also, my lord. And I have been restrained. And this growing age principal factor will be, suppose assuming there is a bar, it will be applicable to me also, my lord. It is not something applicable to him only, my lord. And apart from, my lord, there is no whisper in the entire plain how this growing age will cause irreparable loss and injury. Nothing is there, my lord. Now, irreparable loss and injury, my lord, how it will be seen, my lord. Suppose, my lord, as I have submitted already, my lord, if I succeed in the suit, my lord, how it can be compensated? Re-election cannot be, my lord. This tenure will go away. But for them, my lord, they can be allowed to contest next time also. Even if we say that there is a age bar, court can always modify the order saying that that age bar would not be a factor for considering because they want to contest only, my lord.
Can condone the age bar.
My lord.
You want to say something?
My lord, extremely sorry, my lord. My lord, at number 6 and 7, my lord, I feel my lord, revision would not be met. So in my,
That's what I said.
Petition remain, my lord, and keeping the maternity open, my lord, that would be best, my lord, because the revision will not be
This-
maintained.
I suggested you.
Revision will not be maintainable, my lord.
Ah.
That's why, my lord, in my respectful submission, instead of withdrawal, let it remain. And my lord, I have talked to the
PP.
PP also, and let notice be issued, remain, let the issue of maternity remain open. And TCRs will be required, scan copy of TCR.
I
And
said
in-
so, you did not
and-
agree. It's
madam,
okay. I'll change the order.
Yes, ma'am. And the interim order, my lord, may consider next
Next.
on receipt of TCR.
Yes. I'll change it.
My lord, time
Yes.
after break.
This
Yes,
is
ma'am.
it's already one. How long will you take?
My lord, I am finishing these grounds, my lord, and these grounds will cover all the things in the second also, my lord. And 2, 3 judgment, I will just read. Even I will not read the paragraph. I will just give the para number only.
I'll read it.
Yes, and some facts I need to show relevant facts only in the next these things because certain facts will be different.
Next, you have to tell me what is
Yes,
the
only
difference.
the yes difference. That's only I will do well.
Otherwise, it's finished.
I'll
only.
almost
I'll
finish,
do
my
so
lord.
many order and
My lord, I will sort, my lord.
And then they can do it tomorrow.
Tomorrow.
My lord, it may be one information item. My lord has granted me 2 days for service on the responding. My lord may grant me a week's time.
Week's time.
For 4 days. I have come from Delhi, my lord. I
Ah,
just take a day of off.
Okay, okay.
Two
We'll
days
give you some more days.
4 days, my lord.
4 days.
Yes.
Yes.
Hmm.
Appreciation of it. So as the documents will not take into consideration. That's why the issue of is reversal. First, my nomination filed by 29%. There has not been discussed at all.
In
Not
the
taken into consideration.
yes.
Then I will this letter dated 399 performance election commission informing to the offshoot that election was sustained, not taken into consideration. Newspaper publication not taken into consideration. Result was widely published. Their court taking ceremony, this was also not taken. And most important that that order dated 8/12/2024 issued by the President also modifying its earlier revocation order.
That one you had shown.
Yes, ma'am. It's one of the most essential document on the basis of which the interim was passed, ma'am.
Yes.
This aspect has not been also clear.
8/12, right?
Yes. Now, my lord, another submission, my lord, that the London Trial Court has considered the well-established legal principle of acquiescence. Acquiescence for honesty. You have waived your right, man. Challenge them. And moreover, my lord, during the entire process, they never challenged this election process. They never raised the objection. And even to the APSO also, they never write any letter expressing that objection that this happened also. Straightly they file the suit and obtain that agreement. Thereafter, my lord, on procedural irregularities, where the London Trial Court has failed to consider, my lord, the temporary injunction, my lord, is an equitable release. It is an equitable release. The parties who approach the courts should come with pleading. And my lord has seen that in the plain, my lord, they have first said that misrepresent the fact that the prohibition of the deputy commissioner subsequently revocation or brought on record. The APSO's recognition that it had not been brought on record. And other factors also have not been brought. So it's an equitable relief. Therefore, yes, the trial court should have declined to exercise its discretionary power in favor of the plaintiff. Now, my lord, here is a well settled principle of law, my lord, under when this injunction can be done. Prima facie, conduct is very important. 4 factors. Now,
3 factors actually.
4
Acha.
conduct.
Conduct.
Conduct is one of the most important. What happened? Suppose all the 3 you have satisfied. But suppose the court, after suppose much delay, you may have rightly instituted, but in the process you have allowed the parties to do with the thing. Then you will approach the court saying after 5 months, 7 months, 8 months, then for the conduct you are not in time. Because in the meantime, lots of things can happen. So that is also important. That part also, sincerity of that has to be also explained.
But normally in all those judgments that I have seen, Supreme Court has said
These are
3 golden principles. Conduct.
Conduct also emphasized.
And in fact, I think even I'm not very much into civil matters, but I think if one cannot establish prima facie case, then even convenience, no use. Irreparable or balance of convenience will not come.
No.
First part he has
First
not.
part, prima. Then, for instance, okay, you may have a prima facie case, but if you don't have this, then you are not in time. Now, the first one is again saying, you may have 3 of them also, but if your conduct is out of reproach, you are not in time.
Give me the judgment.
I will. But judgment so far, I will take some the another case also. I will take then judgment. I will be that will cover all the.
Yes.
Now this case, madam, now I conclude with this. For submission is that has not adverted this case. All this might be the minor basically. Basically, this is the case where I have not been even heard.
Yeah, this is to add into
Absolutely.
expertise.
Yes. So now, madam, I would like to.
Absolute also. Kind of you had your. No, you had prayed for time, but then, okay.
Even though yes, at least even I was not already heard. I think learning factors should have adverted to my written statement and documents there. At least, even in the absence of oral argument, even at least those plea which with the records I have put into that should have been discussed, not discussed. Now, next case, my lord.
This case you are over, right?
Yes, ma'am.
These are your grounds.
Yes, ma'am. Sir, Jasmine, I have
You'll go.
right here.
In this 04.
Yes, ma'am. 0. Basically, it is also the same frame, same drafting, all the elements are the same. Only about the plaintiff. If the plaintiff number 1, first, one of the most important aspect of this court case will come. They have approached the trial court after almost 7 months from the declaration of them.
The results.
Yes, from the declaration. 7 months. Now, this plaintiff number 1, he has filed a claim that is saying that his punishment that was imposed to him has been revoked by the absolute. Earlier, the punishment was imposed, that's why he could not file. Since it has been revoked in December.
That one which you have
Yes,
shown.
now I am giving you
410 or some.
that part. I will come to that. Now, plaintiff number 1 about it. Now he is saying that in the month of December, that order which I have sold that one. Now he has used that order, saying that 2 or 210 that order has been revoked, and by that order that punishment was imposed for debarment for 6 years. Now he has misconstrued that order, saying that since that order was revoked, now I can contest the election. So therefore I am approaching the court. That's why delay has happened. But still then my approach after 7 months. Now subsequently my lord, we obtain the clarification from the absolute, saying whether that punishment which has been imposed, then from the student union activities for 6 years after the plenty, whether it has been revoked. Absolute has clearly said, I will show the document, no. That revocation is specifically only to the union activity, but so far that punishment imposed bail upon the plaintiff member, it is as it is, there's no revocation. This bail is for 6 years.
Oh.
Now, this specific plea was taken before the learned trial. First ground that once, because his case is that he wanted to contest for the post of question. But our case is that he never filed a nomination. Initially, he saw the interest for contest, but he never filed a nomination. That's why in the absence of nomination, he declared other candidate. Now the question became very important. Now, this claim so far the plaintiff numbers, it is almost no use at all. It's only for an academic purpose only. Even suppose this title suit is allowed, he cannot contest for the president post. Because his bail is for 6 years. Now, tomorrow, suppose he succeeds. An election is held. Basically, he's saying that I want to contest the election. Now, this because of this bill, he cannot, because he assaulted one of the absolute representative who was there to supervise the election. So he assaulted. So because of that, this ban has been imposed upon him. So first ground that he has no opportunity because he cannot participate in the union activities. Because development is for 6 years. So that he can. Now another ground, my lord. Then another ground, my lord, this non-joiner, everything will be the same only, my lord.
And here also same.
Same, my lord. Locus standi what here we come. First, plaintiff number 1, who is the respondent number 1 here. He has been debarred from participating in APSU and its federal union activities for 6 years. While resolution 2024, meaning they are in 2030, until this order is not revoked by the APSU. And he has not put some challenge to this revoke, this order even. It is still very narrow.
But he is relying on that.
He is relying on that and saying that APSU has modified me and allowed me. And APSU has subsequently claimed. And I have put on record, I have brought on. And they are not disputing that part. Now, second one. A clarification letter is 29/4/2025, annexure D9. I will take my petition. Fine. Page number 232. No. Page 21. This is the revocation order, madam. 8/12/2024. Misinterpreting this order, he submitted. Then clarification, my lord, will get page next page, 22. Clarification. 29/4/2025.
Yes.
I will read from my second paragraph.
29/4.
My 29/4.
And the earlier one was?
8/12.
8/12. Okay, 24.
Yes. Whereas 2, my lord. Whereas in the same order, Sri Chera Chachun is the plaintiff number 1 here. Was terminated from the primary membership of APSU for a period of 6 years, effective for executive order dated 2/10/2000, following a grave offense among the serious breach of organizational discipline and misconduct against the FSO. Whereas it has come to the notice of Household that the order dated 8/12 has been misinterpreted or briefly misrepresented by certain individuals to suggest that the earlier suspension of Mr. Chera has been revoked or verified. Now, therefore, in the interest of clarity, discipline, and organizational integrity, the Household hereby issued the following directives. The suspension order of Mr. Chera from the primary members of Household for 6 years as per executive order that shall remain valid and fully in force until its natural expiry or unless revoked in writing by the absolute president. The executive order dated 8/12 so pertains solely to the temporary resolution of the committee for solution to the ongoing district which was formed to address the internal dispute of the absolute. Any dissemination of false information regarding this order shall be given as delivered and delivered so and so and so. This plain, this cause of action is also based on this particular statement in this one. That I have been allowed by the offshoot, and his explanation of the delay also is like that. Why you have approached the court after 7 months? His explanation in the plain is that earlier, by order dated 2/10, I was rewarded, which was revoked in 8/12. That's why I could not approach. But this said I approached in the month of May. Even after that, there is a delay of 5 months. Even after revocation, that is his whole explanation. Now, I don't.
As a matter of fact, he cannot.
Yeah.
He has no locus.
For no law.
Then
Now, hereafter, my lord, I will turn to another part of locus study. Now, my lord, under the Constitution, as per Article 11G, Part 4 of the Constitution, there is a requirement that if anybody wants to contest the election, one has to get himself enrolled. The plaintiff number 1 and 2 in the earlier case, they had enrolled themselves. But here, these two plaintiffs, they have never enrolled themselves. No contest. If somebody wants.
these two petitioners have never entered.
Never. Now, Article 11G, Part 4 of the Constitution, might have we find that
If the
Constitution.
Hmm.
26, page number 26, 29.
of the petition.
Madam, sorry, madam, this, madam, we find is 180, sorry, madam, start from 180. 1149. What?
Where is 11G?
182, page.
182.
Yes.
No, 182 is the constitution. 11G.
We have a question, madam.
11G.
11G.
Okay, yes, I've got it. To contest an election, he must have
Yeah, madam.
to
Page number
register
188,
enrollment list. Okay.
Page 188, madam.
Yes, I've got it.
Yes, this is one of the ground that he doesn't have locus standi. Why? Because he did not enroll himself as a candidate. So unless you don't enroll, so question of even filing nomination is not permitted. In other case, they had enrolled. Nomination file, that's why we did it. So this is here in this case, this two has not filed. Thereafter, my lord. And then these plaintiffs, who are the respondent here, they are not eligible to contest for the post of president in general.
Why?
Reason being, my lord, Article 10, clause E, F, and G. There are certain conditions are there.
Article 10.
My lord, Article 10, clause
Article 10, clause.
Clause E, F, and G, madam. I will, because here, my lord, certain
Yes.
experience is all for me.
1 to 3 years of service as a central executive member.
My lord, I'll just read this one. Article 10, madam, E. To become the president and general secretary, one must have experience of 1 term, 3 years of service as a central executive member of APS. There is no whisper in the pen that they qualify. I have raised specifically in my defendant. They have, by written statement, they have not disputed this kind. Now, there are F. To become president and general secretary of the, he must be a former president and general secretary of the two branch student union in so and so, which are the federal unions. Another requirement. This is also not there. Now, thereafter, I have G. To become the president and general secretary, he must have experience of at least 1 term of year as a central executive of the absolute. This is also not there. Now, my third law is Article 11A. Article 11A says, he shall not be a member of any political party affiliated organization. This plaintiff number 1, who is the respondent number here, he is a member of BJP. I have a document where he. Let's go to the copy of the notification. My time to page number 199. Type copy my page number 200. In the nomination paper, he endorsed as a member of the BJP.
This is nomination papers for something else.
For Jila
Parishad member. Okay.
That copy my is called.
Oh.
200.
Yes.
I nominate as a candidate for election with the Jila Parishad member from the lower general seat. Candidate name is Sri Chera Tachum. This is also so and so. My name is Sri Chera Tachum, and it's entered as serial number 76 and so of the electoral roll of Jila Parishad. The above name candidate assent to this nomination and thereby I am set up by the election by BJP party, so and so. Now,
this may be later.
No, madam. This is of the year 2020.
20. And election 24.
23.
23.
24.
24.
Election 24.
Okay.
Now, this is another, my lord, where the law, our constitution says that, my lord, no, you cannot be the. You cannot contest because you are an active part of the political party. And it is so clear in our constitution. This all is we have taken in our written statement. But my lord, we find in the imperator, I will read, not a single discussion, not the issue why should not be this be considered. This should have been considered. Thereafter, my lord, prima facie said thing, my lord, that prima facie also, my lord, if I say all these things, if I say that prima facie will say that he cannot file that case. Rather than going to say that he has established that case, rather this should be taken against the plaintiff saying that they don't have the locus to file that case. But here, my lord, just contrary to that, the decision has been passed. This one. Now, my lord, this balance and convenience for all these things, my lord, here is the case. It's more, this case has more merit than earlier case because earlier case at least they have enrolled their timely across the civil code. Maybe they may not be entitled for it, but they are conducted. But here in this case, after 7 and 8 months, explanation is not there. Nothing is not. So therefore, my lord, other factors are all are the same thing. These are the basically he is not eligible.
And what about plaintiff number 2?
2 also, my lord, this political party he is not there, but all this disqualification he is there. But
disqualifications will be there.
yes, he is there, but there is no ban on him from us. But that disqualification criteria is there. that is applicable to him.
He cannot contest for the general secretary.
General secretary.
And what else?
General secretary
Ah.
he cannot.
That okay, by the constitution,
Yes,
but otherwise, no locus because of these.
yes, ma'am. And they have approached very big after 7 months.
Hmm.
Now, my lord, let's for my lord, even I got I inquired from my client. If we say that general secretary, if we say, court say that, okay, contest whole re-election for the general secretary post.
Hmm.
My client, they are even ready for that. We don't want to take freely. But I am saying, my lord, president they cannot do. Other posts cannot be do. Only the one post general secretary. Even if I say that, even if I don't go for all this technical, if he wants to contest, we also don't have the problem. We are ready to face the contest. We don't want to take the pre-cake to somebody now, because at the time he did not come. But this is why just showing that we are always ready to contest. Even today we are ready. But the problem here, these two persons has a fight only for the president. President, he cannot. He is out of person. Not general secretary. And the most even this submission I have made before the elected platform also. This petition can be posted, and therefore, according to the general election for the general secretary post also. Why should we keep the matter and my lord, the order I will exist. All the executive posts 29, all they have been. This body has completely become different. Now, if court thinks that, okay, they have made out a case, they have modified it. And I was ready. Even my lord, I have made submission before my lord event that we are not saying that we will not contest. Although he is not eligible, because tomorrow even nomination paper is scrutiny even in his hand. How he will fulfill this requirement? But even then, even if contest, we are ready.
PW2 had also not filed his nomination, nothing,
No.
right?
But it's still my lord, it is because we know it's my authority. This everything is happening because of the technique number 1 here. Earlier 2% they were with us. When KBN was filed in their name, they were under the misconception that because since KBN was filed in his name, then he put some other person who were in our favor, he managed it and he broke you down. And the land trial court also may be in the same idea that since prospective petitioner was not sent, then pass the ID, then he was succeed. Now, why they have approached blatantly? Now, in earlier petition, the plaintiff has been appointed a president in some other occasion. Last occasion.
That you have said.
Yes. Now, here I have had so many issues that they have participated, and they came to know that this petition will not survive anymore. And misconstruing the order of the absolute. Thereafter, he came. All the time he was shooting from the backside. Then he had to come after 7 and 8 months. This is basically the case. My lord, this is the issue order, my lord.
Well, what is the impugn order here in this
Fine.
case? Same type.
Here, my lord, I was hurt.
You were heard.
Yes, ma'am. Here, my lord, I was.
Here though, you had your caveat also.
Here, my lord, here in the case, here it was for 90 days. It was
Oh.
already expired. But land tracker below, since he knew that already we were restrained by the earlier order. So there was no harm, no necessity of passing the order.
Oh.
Very interesting, my lord. Subsequently, opportunity was given to me. Then, but the land tracker again, he take this interim order to pass this interim order, has relied on that as interim order.
Oh, while passing this.
Yes, my lord.
Because
So
there is the
that
order
interim
there.
order, it was passed without hearing me. That order has been. Now, my lord, we find in that order, in making my lord absolute order in earlier case, he has relied on this order, and in this order, he has relied on that order. This is how.
Let me see the interim order here.
Start on page number 21. I will just go to the final relevant point.
5-5. Yes.
After clear both sides, after careful filter of the entire case, I have found that both sides are not disputing the fact that there was an electionary process for conducting election service. Immediately, the election process was seated from Vidaran or we had from Suez. And the same election process was declared illegal and prohibited by the two orders passed by the Suez. So now here to discuss also, I have advised that subsequently there is a negative. But that is not been taken.
But there, I think you have to clarify me one thing. There is an order of 27-9 that law and order was there. We had revoked, but then now members are present and they have said that they will maintain law and order, maintain peace. And if the election is held, it can be held. It is somewhat in a couched in a different language.
Because it happens something. Initially, was the resolution could not come between the parties. Then the deputy commissioner told me.
You see the order? Where is the order? Just see once. If election is held, then they will maintain peace and order.
Yes.
Right. But not in a way that I have revoked and revoke is there.
No, my lord, revocation is clear, my lord.
But show me 27th, huh? There is one, there is.
Before that, my lord, may I take my lord case number 211? Why this reservation was questioned, my lord?
211.
Yes, my lord.
Yes.
My lord will find case 1. What happened, my lord? When this prohibition was issued, passed, then my lord, the earlier president of the union, he submitted the request. This is the request. To the deputy commissioner saying that almost all the issues, grievances we have settled. I'll just read my only saying that my lord, fine. All this has been issued, my lord. Thereafter, my lord, last paragraph 213, my lord. Page number. Therefore, in protecting the student fraternity of going out for the interest of women, I ask your good authority to cooperate as in election. So with this representation, he went to the deputy commission on 27/9. And he personally refused because he had a responsibility since the earlier president, responsibility to conduct the election because he was the first who appointed for those elections. So when this was prohibited and he went there because meeting was supposed to, so he went there with all this representative. Following which
The same day.
Same day.
27th October and this
27 September.
or September and 27 September.
Yes, ma'am.
Wherein an executive order 26 September was issued.
Yes, earlier.
Earlier, so the temporarily prohibiting.
Yes. Then
Okay.
I went on 27.
Matlab the earlier date, the previous day.
Yes.
And whereas subsequent to order, a meeting was held at the DC conference on 26, 11 hours.
Yes.
Morning.
Yes.
In the presence of so and so. To review the status of law and order situation at so township with regard to so. So morning on 26th, they had this meeting.
Yes.
Until 11, that earlier order was in force, prohibiting. And whereas on threadbare discussion about the marathon meeting, during the marathon meeting, all the stakeholders fully assured to maintain peace, order, and tranquility in case holding of the aforesaid event. In case the election is held, they will maintain order. Therefore, 26 September order passed by this office is revoked.
Yes, ma'am.
It's not like hold the election. If the election is held, then this is.
But they don't have any say on all those.
Yes.
They have only, at the most, they can determine law and order.
And what about the other 27 September order? Where,
One thing, madam, before I take up. Now, madam, even if I say, assuming for the sake of argument, then there was a prohibition order in effect. But in fact, even if I conduct an election, madam, can it be said that the entire election is illegal if it is held? Maybe I may be liable for prosecution for violating the criminal aspect. But on that basis, it is for the sake of argument. Because yeah, authority has not statutory authority to supervise my action.
Hmm.
Yes, CRPC only sees to go and talk. Then if I violate my law, definitely I may be prosecuted. That is another aspect of it. So this for the sake of argument. But we did not go for that one, my lord. When we opted revocation, this is another side of argument.
But there is one more notification, say 27/9 only, where the DC has stopped the election.
Yes, madam.
That is at 141.
Yes, madam. We have disputed that order because we don't know how this order may be. But they have not disputed our 27 in our plan, in our. So our case is my lord has seen, even my lord is slightly quoted, 26/9/2024, mine is. What is saying? Is it saying my lord don't do no, don't hold election? The intention is very clear from here. Now it's saying that they will resolve the matter within themselves, stakeholder, and they shall not cause any law and order. There is no specific prohibition that you don't.
Okay, that I've accepted
Yes.
that, of course.
There's on 27 ballot, now they are relying also in one sort.
Yes,
So,
141.
yes, ma'am, which we have maybe before the arrival of my lord this president with the representation, it might have been passed also, madam. But we have disputed, let them prove it during that trial, how they have obtained, whether this was passed by the deputy commissioner or not. But they have not disputed this 27 order. Now, our state is very clear. We went with the representation, president, informed the thing and requested that then immediately on the same day, revoke, then we proceed with the further election. This is basically the case. Now, my lord, we see here. Now,
No, I'm not satisfied with this 27 September 24, where it is said that as held a discussion in the meeting of 26/9, no, the election will not be held. So shall not be held as discussed in meeting of 26/9. So 26/9 is this meeting of all the stakeholders.
yes, madam.
And this 26/9 only they decided that if in case the election is held, they will maintain order.
Yes.
So this order was revoked, 26 order is gone.
Yes.
But then again 27, he comes out with a new orders.
Yes.
This is in charge deputy commissioner, same.
Yes.
Same order that the meeting, whatever is discussed in a meeting, election will not be held.
That is clear.
So many disputed
And
facts.
our case is also, madam, it's nothing like that we did not obtain now. Our case is, as not pleading, my lord, they have not disputed ours. But we have disputed, we don't know, and we have put through, we have raised the doubt about this. Now, my lord, this order, my lord, says that on 26, my lord, before that, my lord, 26, their meeting was there, my lord. This, my lord, will see. Before that, my lord, this meeting, there was, my lord, one order, he said that he has relied on that one, where my lord, prohibition was issued. Thereafter, this meeting took place.
Thereafter this meeting.
This meeting.
Then this decision.
Yes.
Then again this decision not to hold.
Now he has again come with the on 27 order now. But our case is that maybe in the daytime or whatever, we don't know. We don't know at all about that order, madam, but we have raised a doubt about that order, madam. So for our is concerned, madam, they have not even if it is not genuine, madam, we will not know who has passed what order. We are concerned, madam, that and this order was not procured from personally even. Was the earlier question. He went with the representation. He discussed the matter, madam, and following which only this order has been passed on. So that's why, madam, my other leg of argument, even assuming even, because deputy commissioner doesn't have any role of conducting our internal discipline, whole time. Otherwise, but in our case, madam, we have approached the deputy commissioner. I can see from the minutes of meeting also that minutes of meeting 26, it clearly says, madam, it speaks about the intention to allow. It's saying that.
And one thing, there is a difference of the dates. You see 27 and 28. But it is 28 and 29, right? To hold election. Oh, it's there 27 September order where the the DC has ordered not to hold the election. There, of course, the dates are different, 27 and 28, but then the elections were held on 28, 29.
Yes. After, because for us, madam, on 27 itself, we got the order, revoking earlier order. So therefore, we proceeded. The election means what, madam? We waited there waiting for the nomination. No rival candidate came till to it. Then question of voting, all those things didn't. Then went there. This is the case. So now otherwise also, madam, here, now we are here not all the people, those who want to contest the election, any people are not. 2% minor has seen the earlier petition, they cannot be the agree person. Now this here, madam,
They also cannot.
cannot be. Even that's why even general secretary, my lord, rating number 1, he cannot. Now general secretary, we are ready, my lord. This given.
Acha, on 5-5, what is the final, the impugn order? What is the final direction at interim?
Review order, my lord. They again same similar order, that is staying the entire election result.
Prima facie, balance of convenience, and irreparable.
Now, my lord, it is something like this. This order is basically based on the interim.
Passed in the other case.
Yes, and that interim order, my lord, is seen. Even the subsequent order has not been passed after the hearing. And this order was passed before, before the another interim order, So this order basically relying on a interim.
That was 10 January.
Yes.
This is 5th of
And
May.
nothing, my lord. And that order was passed without absolutely hearing.
Okay.
So in that now, my lord, with this, my lord, I conclude my argument that, my lord, I will cite some judgment. Since plaintiff one has no
Okay.
this has become only for academic purpose only, my lord.
Let's see what Majumdar says.
My lord, judgment, my lord, let's start with my lord. I'll just keep the paras only, my lord. It was 1994, my lord.
You are giving me the prints.
My lord, I'm giving you. This is for my lord, para 18, 19, and 20 for KBL, my lord. The same way, without hearing the KBL, my lord, it's illegal without jurisdiction.
Even if the prospective people are different.
But here the perspective is not different. But here only on the issue that without KBL. But so for perspective, I have well through that judgment. Today I will think my tomorrow itself I get.
Tomorrow morning they are.
Yes, I will.
What is the paragraph?
1893. Then I will. This is paragraph 4, 5, and 6 regarding principles governing grant of temporary. This prima facie all those. Then 2008. I have booked it.
Oh, she can take out the prints. 2000? 2008.
11 SC. Page 1, madam. Paragraph 21, 22 to 27. Here, my conduct of parties have been discussed.
On that, I'll
Yes,
have to say.
even in Dalpat Kumar also conduct has been discussed. The same way, conduct is also the relevant factor. Only satisfied this she also not.
Just give me that book once, I'll see the
Yes.
paragraph. Achha. This one I did not know. It must also take into consideration conduct of parties.
Yes, ma'am. Even research in 2020 also they have never. This has been consistently said. Therefore, last judgment. Most probably, I think the other party also will rely with this judgment. One limited and another. That's the scope of appeal.
The scope of appeal, what appeal?
Appeal this under order 40.
Achha.
First appeal.
First appeal, okay. What is?
It's basically appeal. Basically, my role will see that whether the judgment is the interim order is suffered from perversity, irrationality, arbitrary. Otherwise, if it is not there, then any finding by the learned trial of the appellate professor interference. Because it is called the appeal in principle. It is not as appeal in other regular appeal. So in my case, what I am saying, what is the perversity in this? Perversity in the case is that all my relevant document, all those things might be not discussed. So and the relevant document upon which the judgment is based, subsequently I have clarified that those documents are not very good. That's why this is a perversity. Prima facie, and this prima facie, my lord has seen their state, this Locus study, how they can file under one circumstance. Apart from these 4 principles, in judgment, my lord will be looking after whether these 4 criteria, prima facie, balance of the compliant. Hereafter, again, my lord, perversity is there, rationality is there, reasonability is there, and all these aspects, that part has been discussed.
No, this will come at the very outset.
But outset, they will
Those
also,
balance will come later.
And I know that they will also rely on this.
Paragraph what in this vendor?
There are
9.
There are 9, 13, and 15. I conclude my arguments.
Yes. No, this appeal is you have filed under order
43, my lord.
clause. I have seen it once.
Order 43. Rule 1, clause R, my lord, read with section.
Rule 1R.
Yes.
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 And that rule CPC you have given me once, no? CPC. No, CPC. Give me CPC. CPC you have given me once, no? If PBS, I was looking into years. Order
43, my lord. Again, the order, my lord. Again, the order under rule 1.
R.
Of the order.
An order under rule 1 and 2 and rule 4 or rule 10 of the order 39.
Yes. And this interim order has been passed under rule 1 and 2 of the order 39.
Rule 1 and 2 of 39. One is where temporary injunction may be granted. Rule 1, na? Where temporary an injunction to restrain. So, other injury of any kind, it's there, na? Other injury of any kind.
Yes, ma'am.
Okay.
Covers here. So basically, madam, why has the prima facie is valid put? That is in the probability of the meaning prospect also. That is important. This is the case where No locus standi, no, nothing is there to say that any other parties like all the post, no one is.
No, till then I'm okay. This court is satisfied, but only with 27 September notification. If we, if
Then my argument will be my argument will be that 27, the order which I am relying, that is not disputed. This is the issue. And relying on even if it's there. That it was not revoked and we held an.
in the afternoon of 27, he might have taken out that notification. But then again, they said that election as was declared on 27, 28. That means on the same day. But the election was held on whatever election, I mean.
Election nomination.
Election, yes, election was held. No requirement because nobody is there.
There was no rivalry.
I think the RP Act will governs that some section where people wins unopposed. Then in that case, election is not required. See some. See section 53 of the RP Act. 53(2), I'll read out. If the number of such candidates is equal to the number of seats to be filled, the returning officer shall forthwith declare all such candidates to be duly elected to fill those seats. So if they are not more than the seats, if they are equal to the seats, then it's not required. They will forthwith declare the election results.
Otherwise, where are the persons those who want to contest election from other?
Those are
Only
okay.
4 posts, there two posts is still vacant. If they don't want to take these 2 places, they have been elected by their position of declaration was not there. Now president and general secretary. Now president he himself is barred. Now where is the angry person before the election? If suppose even no election was there, if the angry person is not before the court, saying that I have been deprived of right to contest the election, can any relief can be given for general that no election was held? Specific individual has to be. Now my case is that like that. Now so far two candidates so far plaintiff in the first earlier FAO. But they have been declared elected. The question of there is nothing. Now in this case, one is even if the election was held, he could not contest. Well, now he cannot take the issues of all that, and there is no pleading even then who wants to contest. Well, had it been that case, I have this. I will say that some genuine person who is disabled, who wants to contest, and election was not held. And I tried to file a nomination. I was not allowed to do. That would have been, it may require the actor. Even in such cases, my lord, in election matter, interferences for that piece. Because here, interests of 2% contending parties are not only involved. 1074 delegates are also.
Okay, I will be confining myself to this injunction only. You have finished? So tomorrow morning? By online?
Tomorrow morning is not possible. Today is coming from Siliguri.
This is not done. Then tomorrow, the day after, I'm not doing.
No, my lord, second half.
When will I write the judgment?
No, I'm just praying.
Because see, this matter was made parted not yesterday.
No, I'm praying
it
for
was made parted last week. Yes. And you had enough time. The clients had enough time to engage other advocates and get the matter prepared.
Of course.
And then today morning, you have, as he said, that today morning. This is not done. You already made it parted. I've heard him enough.
Yes, my lord. Tomorrow at second half, my lord.
Second half, how can I write the judgment? Imagine day after tomorrow I'm leaving. You should have something on me. I mean, you have some pity on me.
Yeah.
Otherwise, he is there. He can argue the matter.
No, his part he will do today. I think
11 I will complete today.
The other one.
Other one.
Okay. Tomorrow, Mr. Majumdar has to sum up.
Yes.
He is a senior advocate of a high caliber. He'll just sum up. So he will sum up in the first half. If not 10:30, at 12 and on, he can do it in the first half.
The second half.
You are there. You will assist.
Second half will be better, my lord.
Second half will be too late.
No, after completion of the list.
Let him
Still not-
complete
yes,
and
let him
tomorrow
complete.
daytime you do it by 12 o'clock.
Yes.
Okay.
At two.
At 2.
At 12, at 12. Tell Mr. Majumdar. He need not read much. He can appear.
Yes, my only issue is that whether the election was held or not.
Ah, that was what he
And
has to.
2 letter is make it clear, Mala.
Nah, 27 is even I'm
27
not very.
order, which your lordship has read, this was passed before. And the short order that was passed in the letter.
Now this is what even
That's
I think
right.
so in the afternoon.
If there is no election, my lord, what is the question of my Locus, everything? Yes, also do not have Locus. No. If there is no election,
That is my
everything has
striking.
been.
That is striking my mind. Also,
Yes.
Mr. Will not take long, I suppose.
I have to take bit long. Yes, because everything, the facts, those
Come
are
inside, ah.
twisted,
Hmm.
has to be bring it online, Lordship. Since Lordship, we are here to assist this honorable court. So factually, truthfully, we have to whatever there in the record that we have to argue. So basically, in this case, a simple example, little and very simple example. If suppose there is a notification for the post of LDC, 20 posts suppose, notified, but then without holding any written examination or viva whatsoever, if result is declared, then in that another, that FAO number 5, item 8, 2 candidates are coming, despite they have been selected, saying that since there was no any written test, there was no any viva, we are not going to accept this post. Because tomorrow also it will be questioned. Ultimately, we have to go. Therefore, in the suit, in the plaint, what their frame is to nullify that non-est election result, and then for a mandatory injunction, that is kind of mandamus, Lordship, for directing to hold election to the Chief Election Commissioner, whom it was appointed, here in respondent number, I think, 3. So that is that case. And here in this case are the 2 persons who are supposed to be affair for that LDC post, but then without holding any written test or any viva, that result it was declared. So that's slightest standing their footing difference is that much only.
But no, that will not be a similar case because here unopposed winning is there.
Unopposed meaning is there, but then where was the occasion to declare unopposed also, Lordship? May I bring travel your Lordship to the entire facts of the case? Let us begin with the plaint, because normally to see the prima facie case, balance of convenience, irreparable injury, this is only the plaint. Like suppose in criminal matter, while considering the charge, the materials available before the prosecution, that has to be seen. If suppose, Lordship, I file a title suit bringing one LPC or any land document, court has to consider prima facie basing on my document.
Now, plaint I have seen your show me
Huh.
your. show
And
me-
thereafter, subsequently, if defendant comes with written statement saying that no, his land document, it is cancelled, that is always subject to trial. What I have to establish is only the triable issues, prima facie. That suit needs to be go for trial. Now, kindly, Lordship, come to plaint. In this case, introductory part, page 49, in FAO number 4, Lordship.
Page number?
Page 49, Lordship. Just to understand in gist, may I?
Yes.
Page 49.
Hmm.
Dear FA,
Hmm.
that the plaintiffs herein are bona fide students and are eligible in all respect to contest for the post of President and General Secretary, respectively, in the notified 7th General Election 2024 of all Kurungkeme District Student Union. However, without there being any election process like enrollment of delegates, there was no enrollment of delegates. voters, enrollment of voters, submission of nomination papers, there was no occasion, Lordship. Voting, counting, and etc. The dependent number 1 to 4 have illegally declared the result of election by impugned declaration of result dated 28/9/2024 in Lecture 13, wherein altogether 31 posts, including 4 women wing, were declared won unopposed for the session 2024-2027. Thus, the very rights of the plaintiffs to contest the election in fair and democratic method with the participation of eligible voters, delegates, and with due ballot process has been curtailed by the dependent number 1 to 4, and therefore the instant title suit is being jointly filed with relief claim in mentioned in the FRAIR column. The plaintiff number 1 is the student of first semester MA English in Arnodaya University, Lekhi, and the plaintiff number 2 is the student of fourth semester MA Mass
So
Communication.
those facts I know. What do you want to show?
So this is the gist of the case, that there was no any election as such. So therefore, there could not have been declaration of result. Now, I'll be relying on their document only, because if factually each and every fact is presented before this honorable court, I believe Lordship will understood whether there could be any election in that circumstances. Kindly come to their own document, that is kindly page 64 onwards. Kindly make it note, Lordship.
Yes.
Type copy page 65, Lordship.
See, first beginning, 49.
Beginning, Lordship. This was notified for election by the APSU president on 14 September 2024. Kindly, Lordship may keep on noting the dates are very important.
Yes, those are already there on the first.
Okay. Thereafter, Lordship, next page, 20 September 2024, outgoing president notified the election, and he appointed
The Chief Election Commissioner.
Chief Election Commissioner, Lordship. Next page.
It is almost in my mind. Then?
Okay. Thereafter, Lordship, page 70, this is type copy. Herein, kindly note the date. This is on 20 September 2024.
September.
This is issued by Chairman Delegate Registration Committee, Lordship, wherein kindly note the dates. Tentative enrollment of 7th general election of all Kurungkeme District Student Union Akal Association. Now, these are the tentative dates, Lordship, for enrollment, Lordship. Serial number 1, Duimok College, Bini Yanga Women College, Lekhi Jote Law College. These are all from within the periphery of this capital complex, Lordship. And date is 22 September to 23 September. Kindly that may be taken note. 10 a.m. to Swen, and the venue is at NEPA Club Building, APSU office at Itanagar, Lordship. Number 2, publication of enrollment list with submission of claim and objection. Date is on 24 September 2024, Lordship. 10 a.m. and venue is again APSU office, NEPA building. Third, final publication of college university delegates list. Final publication, Lordship. That will be done on 25th September. And same venue. Thereafter, Lordship, kindly come to next page. Type copies.
Where even those who were not enrolled were allowed to vote.
No, Lordship. Certain dispute that we have raised.
Yes.
That was tried to sort out by the caretaker, outgoing President Akatsu.
But ultimate decision was that they can vote even if not enrolled by checking them in the spot of the venue.
No, Lordship. May I read that case, Lordship?
Not read this. This is the last part you see. The Chief Election Commissioner is directed to give due consideration to ensure that the election process remains fair in accordance with so and so. So see, some people were excluded from voted rights.
Okay, some issues it was resolved.
Then?
That is on again dated 23 September 2024, Lordship. Now come to page 73, Lordship. This is also date is very important. 23 September 2024 again. Herein again another notification it was issued from Delegate Registration Committee, that is Chairman and Vice Chairman, saying that tentative enrollment for 7th general election of all Kurungkeme District Student Union, serial number 1, school delegates, that is DSU, BSU, KTPSSU and NNSPSU. Date, notification date is 23rd, Lordship. And then registration date is also 23rd 9/2024, Lordship. Time between 10 a.m. to 4 p.m. Akatsu office building at Colorium. Now they have shifted the venue to Colorium, Lordship. Thereafter, next notification, that is also same date, 23 September 2024, Lordship. This is issued by same Chairman, Delegate Registration Committee and Vice Chairman. Herein also, it is to notify all the bona fide student and aspiring candidate, 7th general election, all Kurungkeme district student, that due to continuous protest by some student at APSU office. Now we are coming on the issue, Lordship. It is to notify all the bona fide students and aspiring candidates, 7th general election of all Kurungkeme District Student Union, that due to continuous protest by some students at APSU office, that is at Itanagar, the Delegates Registration Committee could not proceed the delegates registration of PG and UG student, which was notified reference number so and so 29/2024. Now they are admitting on 23rd September 2024 that we could not have done any registration because of some protest. Therefore, the registration of PG and UG student will be done as given below schedule. Duimuk College again, that will be on 24th at APSU office, Itanagar, Lordship. To publication of enrollment list 25th, NEPA APSU office, Itanagar. Final publication 26. That is also at APSU office, Itanagar, Lordship. Thereafter, Lordship, what happened? The Deputy Commissioner, Itanagar Capital Region, Capital Complex, issued this order on 24 September 2024. Whereas by order number so and so, earlier they have allowed to hold the election at Itanagar Capital Complex. But later it was found, because of some mismanagement, there were so many complaints and there was likelihood of law and order problem. So this notification, it was issued by the Deputy Commissioner. Now, therefore, the permission given to Sri Tar Tahi, that is the Chief Election Commissioner, 7th General Election, all Kurungkeme District Union, to conduct election process at APSU office, NEPA Club Building, Itanagar, from 24 to 20 September is hereby cancelled with immediate effect. Now, Lordship, by the time this order it was issued, as I believe Lordship could gather the facts, that there was no any occasion of delegate registration at Itanagar. Thereafter, Lordship, this Chief Election Commission, he issued another election notification, that is of 25/9/2024 at page 80, Lordship. So far, Lordship, by the time it was issued, nothing has been done. Enrollment of registration, nothing it was done.
But
Now,
they issued this
25th
to
September
hold the
20.
election.
Election notification. It is to notify all the bona fide students of Kurungkeme District aspiring candidate that the 7th general election of all Kurungkeme District Student Union Akatsu shall be held at, with effect from now 27 to 28. 2 days it is given. Venue is shifted to Akatsu. Akatsu stands for, Lordship, all Kurungkeme District Student Union office. That is at Colorium, Kurungkeme District. Now venue it has been shifted. Now down below he has also written the student who are not enrolled, his her name will be given the right to vote on spot verification by polling agent. Documents required for verification include valid student ID card, admission receipt of latest semester original and ST and PRC original. This also, in fact, if we go by the election procedure, he has superseded the power that was given to the Chairman Delegates Registration Committee.
to enroll and everything.
To enroll the delegates. So be that as it may, Lordship. Now thereafter, next page, Lordship. This is order issued by the Deputy Commissioner Kurungkeme. Type copy is at page 82. Whereas in view of reported law and order situation during the enrollment of delegate on 23/9/2023 at Akatsu office, Koloriang, an order by number so and so dated 23/9/2040 was issued to keep in advance of the election process of all Kurungkeme district unit until further order with clear direction to obtain prior permission for taking up any activities related to Akatsu election. And whereas undermining the above order, the Chief Election Commissioner of 7 General Election has issued election notification scheduled to be held with effect from 27 to 20th September 2020 at Akatsu office, Koloriang, without permission and violating the order issued dated 23/9/2024. And whereas issuing of such notification by the Chief Election Commissioner of General Election Akatsu is violation of law and which may lead to further law and order problem. And whereas the election notification dated so and so issued by the Chief Election Commissioner of 7 General is declared illegal, that 25th one, Lordship. Therefore, in view of above facts and circumstances, I, Sri so and so, APCS Deputy Commissioner Kurungkeme District, in exercise of the power conferred under Section 152 of BNSS 2023, do hereby prohibit for conducting of any election process by the Chief Election Commissioner of 7 General Election Akatsu 2024 for maintaining peace and tranquility in the Koloriang District Headquarters. The Superintendent of Police Koloriang is enjoined upon to execute this order. This order shall remain in force until further order issued under my hand and seal. This was on 26th, Lordship. Now, Lordship, thereafter, in their written statement, they brought some document saying that there was some peace resolution meeting and then this order, it was revoked. But that is never the case. Even it be so, Lordship, Lordship may kindly peruse these two orders of 27 September 2024. And Lordship will come to know that which one it was issued earlier. This is part of my flight, Lordship, page 83. Page 83. This is part of my flight. This is the order issued by Deputy Commissioner. It says, Lordship, the election notification issued by Chief Election Commissioner of upcoming 7 General Election Akatsu by reference number so and so dated 25/9/2024 regarding holding 7 General Election Akatsu September shall not be held as discussed in the meeting on 26/9/2024. Now, herein it is clarified, Lordship, though there was a meeting on 26, some peace resolution meeting, but still, we prima facie found that there is likelihood of a breach of peace and tranquility. Therefore, there should be no election. And that 26 order, it was revoked.
They are speaking of only 25th order. 26th order, they have not said anything.
26th order already suspended on 25th order, already 25th, that is already suspended on the 26th by 26th order, Lordship. Kindly come back to page 82, Lordship. 25th order, very specific. This is, it says, declared illegal. This one, first, second, third, fourth paragraph.
Issuing of notification.
And whereas the election notification by number so and so issued by the Chief Election Commissioner of 7 General Election Akatsu is declared illegal. This talks about 25th.
25th. 25th only I'm saying. 25th was stated to be illegal. And 25th order is also said to be bad and that no election to be held.
Lordship.
But on 26th, there was a meeting.
Lordship.
Right. And there in view of the I, so-and-so in exercise of so-and-so prohibit the conduct of election process for maintaining so-and-so is enjoined. Okay. And then, but what about the order that they have placed on 26th? There was a meeting of all the stakeholders.
Therefore, Lordship, that they have come with the written statement. Kindly come to page 214, Lordship. 214 of their appeal petition.
Yeah,
In
this
fact,
is the one.
In fact, this makes the confusion.
But here they talk of 26th September, the meeting.
Lordship.
Because here they talk of this notification.
Lordship.
This one that you have just placed, this 26.
Lordship.
Right? This is the meeting.
Lordship,
So this is 26 was passed from this office whereby temporarily prohibited due to
Lordship.
apprehension of law and order.
Lordship,
Then the second para of page 214, whereas subsequent to the order, a meeting was held and then it was decided to review the status of law and order.
at 11 hours, Lordship.
11 hours in the morning of
Morning.
27th. And whereas after threadbare meeting, it was held that in case it is happened and they will maintain.
Lordship,
So 26 September was revoked.
Lordship,
That means this is revoked, 26th.
Lordship,
This is revoked and after that, what you have placed at 27th,
Lordship,
27 doesn't speak of 26th meeting. 27 speaks of General Akadasu dated 25/9 regarding holding of election on 27/28 shall not be held as discussed.
Lordship, which page?
26.
Which page, Lordship?
No, the one you have shown.
Page number
83.
83.
That 2610 was not at all mentioned.
No, Lordship, it says the election notification issued by Chief Election Commissioner of upcoming 7th General by reference number 20.
Dated 25/9.
25/9. 25/9, this Chief Election Commissioner, he issued the election notification saying that on 27 and 28 there will be election. That was subsequently declared illegal.
That was subsequently set aside.
Ha.
It was held.
That was
It will not be held.
declared illegal. Thereafter, Lordship, there was a meeting. There was a meeting, and then they have, on the submission of their representation, that it was decided that, okay, you can go with the, but that was in the morning hour. But then later on, when it was found that there is likelihood of breach of peace and tranquility, because all the students, they were,
This 26 should have 27 notification. They should have spoken of that. No, there was already a decision that it will be held, maintaining law and order, but still we are not allowing. But see, this 4 lines order shall not be held as discussed in the meeting on 26/9.
at DC conference hall. This is clear.
26
This is clear, Lordship. Because on that meeting, 26, the decision it was taken. And
No, no,
the earlier order is,
you are not getting my point.
Lordship,
26, see this letter.
Lordship.
By this 26th,
Lordship,
the 25 order was held to be illegal,
Lordship.
right? So 25 order.
25 order is by Chief Election Commission.
Chief Election Commission. And then the same order has been it was again considered and said the election will not be held
Lordship,
by this
Lordship,
27.
Lordship.
But in 26th of September at 11 hours, there was a meeting again.
Lordship,
26, 11 hours, perhaps this is the meeting they are speaking of. The 82, page number 82.
214, Lordship.
Now, 214.
Page number 80.
82, I think. This is the meeting, 26 meeting.
Correct, Lordship, correct.
But then, in view of the I, Shri, so-and-so, in exercise of so-and-so, prohibits. But then.
Here also again prohibition. 26
But
is
see, in the 27 September 214 page,
200.
they said 26 at 11 hours in the presence of Deputy Commissioner Koliarang, Caretaker President of Akadasu, Chief Election Commissioner, Returning Officer, all the aspiring candidates, Vice President so-and-so of this so-and-so, to review. So all these people were present on 26/9 at 11 hours and held a meeting. But this is not reflected in this 26
Order.
letter that there are so many disputed things here.
Be that as it may, Lordship, because certain documents they have brought up in written statement. Now, very important. Subsequently, Lordship, after this, what happened? That is more important. On 28, whether there was election or not. That is very important.
28, it is said that all the polices were there in the venue. All they were
That
guarding.
Akatsu, it was locked, Lordship. Where is the question of delegate registration, issuing of nomination paper?
Election as such is not required. Unopposed. No voting is required.
Lordship,
RP Act.
Lordship, RP Act will not applicable in this case. Lordship,
It's not applicable.
no. In this case, RP Act is not applicable. That my brother will also concede. Now, Lordship, after these two disputed order, let us see which order it was enforced. Now, 27, 28, 27 this order it was issued, either in their favor or in our favor. But an election was supposed to be held on 28 in the Akatsu office. But the Akatsu office, it was locked whole day, guarded by the police. There was a media coverage,
This is, I have
and
seen.
the learned senior division has gone through entire those electronic media records, wherein the concerned magistrate who was deputed on duty, he stated that there was no election today, is because we have to prevent the law and order problem. I have been doing my duty. This office, it was locked since from morning, wherein in the media statement of deputy superintendent of police is clearly says that there was no election on 28th since this office it was locked. Now, Lordship, if suppose I am aspirant candidate also, I want to purchase a nomination paper. I want to get myself registered. If the office is locked, where do I do? Where do
The
I?
nomination was on an earlier date.
No, Lordship. Nomination, everything, it was on that date. Only enrollment, registration, delegates, that was on earlier date. That also could not have done, as Lordship has gone through the entire records. Capital Complex, they tried.
Nomination was also submitted on 28.
28, it was supposed to be issued, paper were supposed to be issued. Otherwise, there was no any occasion as per their documents.
Where are the nomination papers? Someone has annexed.
Uh,
At least one of them.
They have annexed so many nomination papers. Let me.
No, I mean, then was it on 28?
Yes.
Nomination papers were submitted on 28, on the same day, and same day results.
Very interesting. Therefore, I'm saying also. So now, kindly come to one statement, paragraph, Lordship, that is page 58 of their appeal petition.
58 of their?
Appeal
No.
petition, page 58. This is my plaint, paragraph 13.
Yes.
That the plaintiff begs to state that on 28/9/2024 and 29/9/2024, the Akatsu office of Koloriang was under complete supervision of the police, and the Spark News channel was having coverage of the same through journalist Mr. Nangram David. He will be a #1 witness, confirming that no election-related activities carried out in the office. In the evening of 29/2024, when suddenly the impugned election result placed in some local medias, the DSP Koloriang, Sri Lishi Longdo, and the concerned magistrate Koloriang, Sri Biri Taha, have briefed the media Spark News that no election-related activities was done or held on 28/9 and 20 in the Akatsu office. Witness number 2 and 3. We need not have to prove bringing so many witnesses also, Lordship. Only if these 3 persons are called, it will be suffice to decide the entire issue, Lordship.
Acha, what about the constitution of the union? It doesn't talk of people getting unopposed, re-elected unopposed. Must be there.
Unopposed can be there, or that at least there should be some procedures.
Show me the constitution.
Unopposed, that part, Lordship, I have not gone through. Basically, our case is simply that, Lordship. When there was no election, like as earlier I have given one example.
No, my problem is like, if everyone has got elected unopposed, there need not be any voting.
Lordship, when nomination paper issuance date is notified, office is open up to 2 p.m., this much of nomination received, and for that post, no nomination has come. Of course, can be declared unopposed. But in that office, it was remain closed. There was no any election procedure. Then how do someone can be declared by
So what
picking
if
it?
they had done everything inside? They have
Not
taken their
inside also,
nomination.
Lordship. We don't know from where they have done, Lordship. Declaration of result, Lordship. This is the case, crux of the case.
So according to you, no election?
No election,
No
Lordship.
prima facie case.
Lordship.
And just show me the constitution of the union once. These are the nomination papers, right? Nomination papers.
so many nomination papers are here, Lordship. But I don't know how could they have.
Where is the, Mr. Sonar, where is the constitution of the union?
Declaring unopposed.
One eighty start.
One,
80.
in the second application. Show me the provision where they are elected unopposed. Try to find out the provision. In the meantime, I'll hear him. Okay, Mr. Sonar.
One is power of the election commission.
Where is it?
Power 191.
Hmm.
Page number 191 -4.
Hmm.
Article 18.
Hmm.
Election.
Hmm. Article 18, yes, election.
Election. The members of the central shall be elected by the members of the election so the delegates so election shall be the secret case of the election of due will be by so shall be prepared by so. Now G madam, Article 80G is also very the contested candidates who have not enrolled their names in the delegate list shall be disqualified from his or her candidature. This is also one of the ground matter that they have not enrolled themselves. Now next matter. Now I'll just refer to this article. Article 19 announcement of election date and time. This is then by the power of the Chief Election Commission. So unfortunately, or given Article 20 power. The Chief Election Commissioner shall be appointed as a president so and so. Returning official so and so so and so. The election commissioner shall be there. Article 21 matter. Power and function of chief. Other election committees shall be appointed by the chief election. At the time of election, any outbreaks of disputes, conflicts, or controversy regarding the delegates members from various schools shall be decided by the chief election commissioner by seeking consultation from the outgoing president, general secretary, branch general secretary, and then school. Meaning there were one chief election commissioner has been vested with that power. All this continues. Second one, the electoral college shall be prepared so. Now, D. The office of the election commission is independent and autonomous in body, and all the election process shall be carried out and empowered them. It is up to the chief election commission how to go ahead with the but this is voluntarily organized. It's not something statutory body or something of government function. This is a common association with the students body. Voluntary association there is by final discretion is based with the chief election commissioner how to proceed with that. Let my friend.
Okay. So I've got your point. The election was not held.
Not held, Lordship.
Then-
And in such type of situation is if encouraged, Lordship. Therefore, this was placed before earlier Justice Honorable Nair also in the past listing during the admission. And then brother was tried for staying the operation of, but it was reluctantly denied, saying that.
I relate it, then I will.
So that day also some judgment my brother has relied that conduct on, and that was also phrased on. Regarding that also, I have noted on that day I expected that there will be some. My brother has relied on that. I think Mandali.
Those are not necessarily strict to your point. And
Okay.
And this.
Because that citation, Lordship, that conduct also has to be considered, because in that case wherein brother has relied that case, that is a case something delay. Because of delay, there was some subsequent development. Suppose I have not approached at the earliest possible time, and some building structure it has risen up. Then subsequently, if I approach challenging that order, then in that case, of course, in that situation, the conduct lately approaching the court when some building has raised up. In that context, that judgment it was given. So that will be not applicable in our case, is because immediately after notifying this result, that other 2%, those who are even selected, but then they are saying that since there was no pair election, we will not accept this post. They firstly approached before the Civil Justice Senior Division, and immediately they got the injunction, ad interim injunction. So only difference is that we are the candidate and they are in the list. And now one more interesting thing, Lordship, in this case, what I found is that dependent number 6 and 31, who are also declared elected, they are also truthfully, honestly saying that, no, there was no election.
That I have seen in the first time.
And then when they have opposed, when they have during the hearing also of that injunction, they appeared and they says that this should be stayed. We have no objection in granting injunction. At least they should have been made party in this appeal. Because this is the continuation process appeal, they should have made party. But then they have not made dependent number 6 and 31 party in this case.
Defendant number 6 and 31.
31.
The
They are also declared unopposed candidates.
two plaintiffs.
They were also the defendants. We
They-
were in the elected body. We are the same. I have got nothing to do with for them. That's why I don't know. If they don't want their post, let them know.
No, not
No,
the.
they are also opposing.
Not the plaintiffs in the earlier matter.
They are the different. They are the elected body of the 20.
Hmm.
So now he has managed some of them.
Hmm.
4 now. Then 4 of them doesn't want the post. Let them contest. But why should we suffer?
Plaintiffs had come and filed their plaint. They did not come, so why? What is the
Despite
reason?
of that, Lordship, in that case, my humble submission that this is also, this appeal is paid for non-joiner of dependent number 6 and 31 also may be kindly reflected. And regarding caveat, Lordship, there are so many things that needs to be clarified. Therefore, I have said that I may take some time. Caveat, when Lordship it was filed,
Other matters not taken. Then, caveat what?
when they have filed the caveat, Lordship, prospective plaintiff, applicant whatsoever, it was the plaintiff in this case. We have been issued with the notice with registered post.
These are the prospective.
And that other person, those 2 persons, when they have filed that petition, they were not the prospective applicant, petitioner whatsoever. They have been not even issued with the notice of the caveat. And therefore, to my humble understanding, CPC, when it's clear that until and unless you serve the copy to the prospective petitioners, so the requirement of hearing for other person.
That is not clear. You see the subsection. It says that whenever any application is filed in the proceeding, may not be by prospective plaintiffs, by others.
But then, Lordship, requirement is that notice has to go.
No, you
And
see
if that
148.
notice has not gone to 148,
148A, see. See 148(2), where a caveat has been lodged, okay, under subsection 1, a person by whom the caveat has been lodged, hereinafter referred to as the caveator.
This is very important.
Shall-
Shall serve a notice
of
of the caveat by
caveat.
registered post.
Hmm.
This is mandatory requirement.
They did not serve you by
Not to them, to us they have served.
to us, to you, they have to
In
serve.
this case, they have served. In that case, item number, FAR number 5.
Those were not prospective plaintiffs, so they have not served. They have served upon you because they considered you as prospective plaintiffs.
Lordship.
they did not think about them as prospective plaintiffs because they were also unopposed elected, right? They
Lordship.
were in their side.
Lordship.
Go to 3. Go to 3.
Lord-
Here they are under 2. They are compelled to serve notice upon you.
Lordship.
Right. That they have done.
Hmm.
Where after a caveat is lodged under subsection 1,
Lordship.
any application is filed in any suit or proceeding.
Lordship.
Any suit.
Lordship.
That is, the statute doesn't say any application filed by the prospective plaintiffs in the suit or proceeding shall serve a notice on the application of on the caveat.
But then until and unless Lordship, if that
In fact, I was also under the said provision, said whatever you are thinking.
because Lordship.
It's under the same.
uh,
Okay, I was also under the same impression that they have to serve notice upon them.
Lordship.
But then it can be even if they have not thought them as a prospective plaintiff, they have not.
Lordship.
So, but even then,
Lordship.
when after a caveat has been lodged under subsection 1,
Lordship.
any application is filed in any suit. That means this miscase is filed in the plaint.
Lordship.
Right. Or the plaint and the miscase filed together.
Lordship.
The court shall serve a notice of the application on the caveator.
Lordship.
So the caveator has to be given, has to be served a notice. See, it's not talking about prospective plaintiffs. You go
Lordship.
and read
It has to
again.
be read together with 2.
2 is okay. 2, yeah, 2 says that yes.
If we leave aside 2 and thereafter directly we jump and read 3, then of course Lordship, whatever Lordship
But see,
is saying is
2,
correct.
3 are not connected. It is not said and or. It is a full stop there. You have to read it independently.
Lordship, 2 it says, kindly see,
Hmm.
where a caveat has been lodged under subsection 1,
Hmm.
it refers to 1.
of
And 3 also, where after caveat has been lodged under subsection 1.
Hmm.
Both 2 and 3 is taking reference of 1.
Hmm.
The person by whom, 2 I am reading 2, the person by whom the
That is the
caveat
caveator.
has been lodged herein after referred to as caveator shall serve a notice of the caveat by registered post, acknowledgement due also required on the person by whom the application has been or is expected to
They
be made.
they expected application from you. They
Lordship.
did not expect it from them.
Lordship,
So they had served the notice upon you,
Lordship,
but not to them. They did not expect.
Lordship.
But go to 3. Even if they do not expect, if some application is filed in the
Lordship.
suit,
Lordship.
in any suit, the court shall serve notice of the application on the caveat. Get some judgments on this. There will be judgments on this.
For me also, I have one judgment, even not hard also, caveator. I'll try to give the judgment.
The same manner, my lord has highlighted that in the same manner that has been interpreted by the.
This is what I
The
want.
same way.
This is what I want. Get the
So
judgment.
now on this caveat also regarding this lordship, in that case, without hearing them as because they were not made as a prospective plaintiff applicant whatsoever, thereafter so many dates it went on, and then they have never put to challenge that it ad interim injunction. That was
They did not file for vacation
Ah.
alteration.
And on that day, learned brother is saying that there was some subsequent development also. For that, Lordship may kindly see there is a provision under Order 39 Rule 4, if I am not mistaken, for modification alteration on the ground that there is
There.
some change. So that could also they have not done that also.
They have not filed. They have simply given a written sustain.
Lordship. And regarding this Lordship, enrollment list, Lordship, kindly see and appreciate the fact, Lordship. They are repeatedly saying in their written statement, in this case also, in that case also, that there are enrolled registered members,
74.
1074. They are saying by words, but then they are not furnishing any document. Therefore, what we had to do, we had to file one application also, Lordship. There is a provision under CPC, Lordship. Specifically, Order 11, Rule 15, Lordship. It says if any document is relied by defendant.
What is this? This is in respect of present case.
In respect of that another case. In present case also, this will be applicable. Yes, because kindly see the statement, Lordship. Paragraph 1, Lordship. That the applicants are the plaintiff in the connecting title suit number 12 of 24. The applicant's case is that there was no any fair election allegedly held by the respondent dependent number 1. The applicants alleged that there were no any delegates enrolled registered for the purpose of 7 general election occurred 2024. Neither the illegally declared elected unopposed executive body plaintiff and dependent number 5 to 33 have filed their nomination. In the written statement of respondent dependent number 1 and other dependents, except dependent number 31, also in their reply to the rejoinder, they have categorically made a statement that the records of delegates registration and the nomination papers of candidates are in the custody of respondent dependent number 1, that is the Chief Election Commissioner. They have further stated that the applicants must be payable for non-impleting of those PEC or non-existence 1074 delegates in the suit. Therefore, what is our fair, Lordship? Para 2. That under the aforesaid stated fact, it is highly necessary that the respondent should be.
Is this the application you have pursued there?
And pending.
Plaint, I'm not hearing on this. I'm only on the interim
But then
injunction.
why I am on this, Lordship? Because in the impugned order, in that case or in this case, this reflection is there that you have to file immediately or you file reply if you cannot produce the document.
No, what I'm on is whether you have a prima facie case, whether balance of convenience,
Lordship.
whether irreparable injury.
Lordship.
So as far as the first one prima facie case, you are saying that there was no election.
No election.
And that was what was held by the learned court.
Lordship.
And they said that there was no election, so he has a prima facie case.
Lordship.
But again, in the, okay, that I will accept your thing. But then again, in the, when the interim or injunction was made absolute, those considerations were not looked into. Because
that was in that case, because in this case, you was heard.
Achha, in this case, you are not.
Senior counsel argued.
There is no absolute, that was not made absolute.
In our case, they have been given opportunity after a lapse of 7 months also. KBS normally expires on 90 days. But then when we have filed it, learned senior division was of the opinion that since long time back there was a caveat, no, we will not pass any interim injunction order. We have to hear them. There I have submitted 90 days already elapsed, but then learned senior division was reluctant, saying that no, notice will be issued. Thereafter, we were heard, thereafter it was passed. Now kindly come to impugned orders. Page 21. Everything is thoroughly discussed in this case. Whatsoever has argued by my learned brother, page 28, everything is also taken into consideration, Lordship. Page 28, particularly argument of my brother. I have also heard Mr. So-and-so, learned counsel for the dependent number 5, 7, 30, 32, and 33, while praying for rejecting the prayer for temporary injunction. He placed the following points. All those points that were taken into consideration, Lordship.
Then,
Thereafter,
what
Lordship.
basis the order is passed?
Pardon, Lordship.
On what basis this order is passed?
Prima facie case, kindly come to page 32, Lordship.
I'm of the opinion that there is reasonable and genuine.
In the light of above discussions, kindly factual expect Lordship may kindly later on seen. In the light of above discussion, I am of the considered view that the plaintiff petitioner has sufficiently proved their case for granting temporary injunction in their favor, as the 3 golden principle for granting injunction has been established as under. Prima facie case, I am of the opinion that there is a reasonable and genuine legal issues that deserves judicial attention, because from the record there is a sufficient evidence indicating that no 7th general election of Akatsu was conducted on 28/9/2024. Yet, result were declared on the same day, which violates the election rules and regulation that breach the legal rights of the plaintiff petitioner. Hence, there is a prima facie case in favor of the plaintiff's petitioner. Now, balance of convenience. in my opinion, the balance of convenience is also lies with the plaintiff petitioners, because if the results are allowed to stand, it may illegitimately install the office bearer of Akatsu, who were never elected, undermining the student body democratic rights. These are the conditions, Lords. On the other hand, restraining the result notification dated 28/9/2024 may causes only temporary inconvenience to the opposite party, but that can be remediated later on. Moreover, one similar case challenging the said result notification dated so-and-so is already pending before this court, which has been filed by two candidates who have been declared unopposed in the said result notification, and one ad interim injunction has already been passed by this court by dated so-and-so in so-and-so, so-and-so. Why this was taken reference, Lordship? Because when the person who has or have been declared unopposed and given the executive post, when he is coming saying that no, there was no election, what more is required, Lordship? The glaring evidence, quite sufficient. Other than that, that magistrates, that DSP, their statement also gone through by the learned court below. Now, irreparable loss, Lordship. In my view, the plaintiffs' petitioners have sufficiently shown that they would suffer harm that cannot be adequately compensated in monetary terms if the injunction is not granted against the election notification dated 28/9/2024, because by declaring the result without conducting election has unlawfully deprived the right to contest in free and fair election of the plaintiff's petitioner. Therefore, they will suffer the loss of opportunity and representation to the student body, which cannot be compensated later on, considering the facts that the student body has the short-term period and they are likely to bar by their age to participate in the future election process of the students' politics. So every year, Lordship, I cannot be remain as a student. Say I am now doing MA second semester. By second, third year, I'll be completing my MA. Thereafter, I'll be no longer a student, and I'll be no longer in a position to participate in any student like organization, Lordship. So these are the factors, those that were taken into consideration, Lordship. In view of the above, I am inclined to grant temporary injunction in favor of the plaintiff petitioner, thereby suspending operation and the validity of the informed declaration of result of 7 general election August 2024 till the final disposal of the title suit. Since the instance case and the title suit number so and so, I being registered are having same facts and common grounds, the instant case may be listed together with the already pending cases on next date with the IN number so and so arising out of stand disposal. List the case on 10/6 for filing written statement by so and so, so and so. So here in this case, only the issue, Lordship, whether there was election on 28 or not. If suppose
any pleadings on your part that you had gone to file your nomination, but you are not allowed?
No, we have simply said that on that day, since that office of Akasu, it was completely low. So there was no occasion for issuing nomination paper or filing nomination
Where is that?
paper.
You have some pleading somewhere?
It's kindly come to my plain, Lordship. And it's starting from 35 onwards. Paragraph 10, Lordship, page 56. That the plaintiffs beg to state that they, being a bona fide and genuine aspirant candidate who believes in free and fair election, have requested a dependent number 1 to 4 for having some patience and to find a suitable place for holding election with due permission from the concerned district administration. However, hastily again, the dependent number 1 issued another notification dated 27/9/2024, wherein he fixed 28 and 29 September 2024 to hold the 7th general election 2024 of Akatsu at Akatsu office Koloreng. However, since the Akatsu office Koloreng was guarded by the police personnel on 28 and 29 September, election could not have been taken place. Neither there was any registration of voters delegates taken place.
But that not in so many words that nomination they were not allowed to be submitted.
In that situation, Lordship, when that was locked, that was carried out, when the notified venue is closed, then it is understood that no one has gone there, including ourselves. Only issue, very simple issue, Lordship. If suppose tomorrow preliminary issues is framed, if suppose it is framed, we call upon the even deputy commissioner who issued that order, which one is genuine one that can be seen, and that magistrate on duty, DSP, and that media coverage whole day he was there. Only 2-3 witnesses if they are called. Therefore, Lordship.
Those are for the plain to see
Lordship,
substantial evidence.
Lordship,
Now,
because
only with prima facie.
Prima facie, Lordship. Prima facie, it is there, Lordship. Therefore, my brother is again, he may oppose that the Lordship, Justice Honorable, you can either say, I have gone through the entire this thing, impeachment order, prima facie case, everything is discussed. So he was reluctant to stay this order.
Okay.
So,
This-
so lastly, Lordship, my respectful prayer would be to dismiss this affair and by supplementing, Lordship, some order may be kindly passed in the interest of both the parties, that trial be expedited, as because student organization, it is not functioning for like 7-8 months. We also want that trial should be expedited and there should be election so that we can participate. So supplementing, while dismissing this by supplementing, some orders may be passed in the interest of
Expediting the trial you have seen.
Lordship.
Difficult, no? I mean, it's not on the fault of one or the other party. It just happens. No, you cannot continue.
Pleadings are almost completed since written statement, everything has come. Only 1-2 official witness, if it comes, Lordship, suffice.
Okay, that.
So my prayer will be for dismissing of this. It's devoid of merit, Lordship. Highly obliged, Lordship. I am in item 11. Oh, Lordship, one
Judgment.
my brother also might have raised this one. Paragraph 20 to 22. Here it says, Lordship, since this is appeal under like principally, it's appeal under principle, not on like merits of the case. So if the opinion given by the learned trial court while granting temporary injunction is reasonable, but other than that opinion, there could be some other opinion also. His opinion has to be sustained. Para 20 to 22, Lordship.
22.
20 to 22. And another judgment that my brother has given earlier, that regarding Mandali Rangana case, Lordship. That Mandali Rangana case, Lordship, that conduct one. I think it is 2008-11 SCC, 1 page 1.
You have? Oh, you don't have. What, 2000?
Brother has already submitted 2008, volume 11, page 1, Lordship.
Oh, yes. You have given the book.
Kindly, in that, kindly it may be seen. There is a case like delay after someone has constructed such a big buildings, raised up those, then only that delay part in that contextual, that can be taken consideration of while granting temporary injunction. So that will be not applicable in our case. That's all.
My friend has repeatedly referred that this matter. Very odd. What happened, man? The matter was discussed for the motion. And this matter was the earlier one. So, most probably Justice Nair might have done for the petition. I don't even take a speech. And he said that as of now, since you are for the stay, first day, since even it will not serve any purpose, since you are already restrained by another order, which is the first item. So considering that, they said, okay, if you want to argue, then the put matter there, they say, you argue there. Basically. How without hearing me? Now my learned friends once, he has done already in the lower court. Even in the high court, he wants to do the same thing. That without hearing me, Lordship has made the mind that I think I was not heard even. I was not allowed to even make a submission. This is a very unfortunate statement from my perspective. Then, my lord, now I will come to the case. Now, my lord is my lord will look into the matter. Please, my lord, sir, before the my lord, all the matters there. Now, my lord, very good. My lord is what? My lord has seen all the events and impugned judgment of the learned tribunal. What he is saying? All the repeatedly issuance of the notification are not in issue. Till 20 is not as part of the election process now. Issuing notification is not. Are they saying that we did not even issue notice? Yeah, this is not their case. Have they disputed any of our notification that we did not issue? Chief Election Commissioner did not issue. Now everything is open. Notification was issued. Time schedule is given, and my seen that it says that even for the delegation there was some distance there. So there was urgency of holding election. What is the extra additional chance was given to the delegate saying, forget about registration. You come, if voting takes place with your ID card, you will be allowed to cast vote, which is generally not permissible. But these steps has been taken. Who is basically empowered to conduct election? Is the plaintiff or the Chief Election Commission? Now, Chief Election Commission, once he has been appointed, now defendant, some of the defendants, we are the interested party. He will have his person, I will have my own person. Now he wants to say, he says no election, and some media person pen drive, when that media election, till 2 PM, no nomination was to say, declared. What they did is like they managed some media person. That can be done by anybody. They brought somewhere after 6, 7 in the evening. They made their video covering saying and put on the social media, there was no election. This can be orchestrated by anybody, man. Now, what my learned friends, that if he say no election had, then the affirmation, the letter issued, nomination, all this election result issued by the Chief Election Commission, no value. Rather, presumption is in favor of the order passed by the Chief Election Commission. But Indian Evidence Act also was. If any order issued by the public order, whether issued or not, always presumption will be there. The order has been rightly and properly issued. It is on the onus on the person who challenges this has not been done. As of today, this presumption is on my favor. Now he wants on the first day, and the learned transport has also on the first day said that no election. Rather, this presumption is in my favor. This will be decided only after election trial, whether election was there. Now, as of today, this entire and these documents have not been disputed. So presumption definitely goes. And who has declared? The person who has been appointed to look after. That presumption is obviously. Now, who has anybody business to interfere for holding the election? Even the deputy commissioner has no business. Under what provision of law he can interfere in the internal matter? At the most, he is to look after law. This is the Chief Election Commission. Now, this is first question. The presumption of all the documents, even not presumption is purpose. It is the admitted. In the learned trial court has said that there is no dispute about those issues. This is first one. Now, so for KBL about perspective, I have done research and I have judgment with me. Tomorrow I will produce one. Now, madam, I saw the misleading check. On that ground itself, this equitable relief by the case one. If somebody makes false statement of fault, that itself, even if he satisfies all the ingredients, but if it is made of false affidavit of false matter, then and thereby obtain the injunction order with the loss, this is an equitable relief. Itself on that ground, they can be denied. Now, that's from my misleading statement from this written as this landmark. I will not make para one first. Madam, trying to page number 49. His statement.
Yes.
What are the false statement he has made? Para one number is saying the plaintiffs here are bona fide are eligible in all aspects to contest for the course of proceedings. I have shown why they are not eligible. First, bar, no reward, plus other requirements are. And they come with the reply of my written statement saying that you see, I meet all the fulfilling required. This is the first statement, not eligible. First misleading statement. Thereafter, I will kindly turn to page number, para 49, page number 59. This will make very clear.
Page number?
Page number 59. I will read.
Hmm.
How he has misinterpreted the order of the plaintiffs basically stated immediately after the declaration of result of any federal unit of the AFSU as an the entire election report is submitted to the AFSU, and accordingly, AFSU recognizes the newly elected selected executive councils of the federal unit. In the case in hand, the AFSU by this order that it has suspended the AKD issue until further order from considering there is serious irregularities on the election question. And also, by the same order, the plaintiff number 2 was banned from participating in any AFSU or its federal unit activities for 6 years, subject to further order by AFSU. However, by order dated 8/12, the AFSU has revoked the previous order dated 2/10 also. The subsequent order dated 8/12 of the AFSU has now released the plaintiff, enabling him to file the instant right to sue, though lately, and has also given a fresh cause of action as the AFSU has revoked its previous order dated wherein it has suspended the state. First, he has admitted that AFSU has recognized as first aspect. Now, what he has misconstrued this order that my claim has been also revoked by the AFSU. That's why now I being filed a suit. The AFSU immediately on coming to know that we went there, then AFSU has given the clarification. But I have shown that order earlier.
Yes, sir.
Now, another is statement. Now, misapplication, my lord. What is the my lord ground given? Misapplication, page number 118. How he has obtained this injunction order in the learning has not even seen what are the pleadings, averments made in the claim. Because my lord, we may make lots of oral submission. If pleading is not there, there's no reason. Our submission should confine to what is there in the claim. Now I am sticking his claim I am reading. Can you turn to page number 118? Now he is reading. The applicants have been on the strong parallel mistake is that despite of there being no election, have declared so and so. These claims are there is that elected unopposed result and they have denied of this election that is therefore it is even more than kind of issue case that there was no election. And election result is declared not as implied by the respondents. So now, the balance of convenience still in favor of the applicant. As on today, the apex body AFSU has not given due acceptance to the election result, and also the review election result is under suspicion by source. First part. This statement is completely. First, in the plain, he is saying that AFSU has revoked its order. And thereby my bail has also been revoked. And earlier revocation is there. Now, here what he is saying, that APSU has not recognized till then. That's why, since they are not recognized by APSU, that's why balance of convenience is divided. This is in the first case also. So what here there is a copy paste only. So he has not find out the contradictory statement is all this thing. Then here also growing age. Oh, growing age. Well, my writing here, at least some awareness should be there. What is the eligibility criteria? What is the age? What is my age? How we are and how just growing. I am also the same. My age will not stop. My age also will grow. It's the same level. Then this contradictory statement of this. Now I will para 60. Very good. Last reference I will. Para 60. Now what is that we can next be still under the clear facts illegality there with the second. And now I say that acceptance and approval from the APSU would validate all the illegalities incorporated in the process taken up by the restaurant number so and so. It is respectfully paid for granting a degree mention before a prior I was saying that by the time already revocation that this was filed at the month of May, revocation was at the month of December. I is saying that if it is recognized, now he's contradicting himself. Now he's saying that no, earlier was revoked. Now he is saying that till now APSU has not recognized. That's why it has to be injunction has to be there. So these are the grounds in this application for asking for the agent. Now my lord. My lord has said, see, this 27 order. Now this order itself is saying notification election of ARC commission is dated 25 so regarding shall not be held as discussed in the meetings. But minutes of meeting I have shown. Where in the minutes of meeting it was discussed that election will not be allowed. This order itself is wrong, man. Why not see page number 82? Because in minutes of meeting, my lord says that only they may be allowed to go, but law and order problem should be met. Now this order is only saying that as the 26 minutes of meeting as we discussed, there will be no election. That's why there is no foundation of this order itself. Now, this itself is in the issue, man. Most probably they have just procured and they have not referred even what is the minutes in the meeting on 26. And
this is what troubling me. This is the and the meeting was held at 11 o'clock on 26th. And 27 that notification was out, revoking. 27 this notification is also out, saying that the 25th notification declared by so and so that they will held on 27, 28 will not be done.
So meaning they are
as if this 26th meeting they were not aware of. It's something, I don't know, this is very hotspot, right?
No, they just 26 meeting, what is there? They should know. Because I have ignored the minutes of meeting of 26. In the minutes, my lord has seen that there was a gathering discussion in the meeting. Says that. But only the things that law and problems should be.
And this is where Deputy Commissioner and the other 26th thing was the in charge DC.
My lord, may at the time maybe he was not present. Now, my lord, another
on the same day.
27, my lord, same day.
See, 26 September, right? 26 September, there was a meeting. This 82, page number 82.
Yes, on 26, my lord, this order, madam.
This 26 disorder. They speak of the decisions. I mean, disorder. This is by Deputy Commissioner.
Deputy Commissioner.
No, this is Deputy Commissioner.
26 is in charge.
Oh, the type copy is no in charge is
Oh,
written.
my lord, type copy wrong. Page number 81, my lord. Is the superintendent AP?
Yeah, this is in charge, but in the typed copy, they have
Yes,
written
ma'am, wrong.
deputy commissioner.
Then, madam, this is also in charge, 27 also.
That is also in charge.
Now,
And
madam, now, as my friends right, there should be in the pleading that as per this notification, we went to the office, we asked for the nomination paper, and we were not allowed, we were not given, even at that point, what is the madam, generally what has to be said? It's like, chief, you can write the application, right? You can raise the objection, right? Give me the nomination paper. It's completely silence.
that is what he showed one paragraph where it is said that the police were guarding, and
Yes, madam.
then they could not enter.
Madam. Now, for him only, 2% only, all these 29%, madam, for them there was no police. It should be applicable to them equally, madam. And this 2%, madam, in the plaintiff number of those who have been managed letters, while we see they have enrolled, filed nomination. And my friend is, they have managed lots of this our call select. Now that defendant who is referring, madam, I have given in my, I saw from my record in my reply also I have given what he did is, he took the oath also. First, he jointly wrote a complaint with us to the APSU saying, don't entertain any complaint from these people. Later on, all of a sudden, even written statement was jointly filed. Then all of a sudden, he out of nowhere, he appears said, I have not authorized for filing written statement. Now later he said no election. No, well, his 3%, let's assume they are the greatest of the greatest person. Those who doesn't want to hold the post, because let them contest election. We are not taking their post. We are only for our post, for which we have applied for. Now, and that's why this all this requirements is not good. Just
Okay, like now in this case, I'll have to go only prima facie. I have heard enough.
Yes.
This is not the plain for final determination. So prima facie, what I find is the chief election commissioner had also said, what I find is the chief election commissioner has given by letter that the election has been held and then this will be so and so. Because see, I'll go prima facie into the matter. I'll not go very deep. That is for the plaint.
Yes.
Here, I have to see whether you have a strong prima facie. You have a prima facie case. So prima facie case in view of the letter by the election, in view of the fact that you have not raised anywhere that we were not allowed to submit our nominations and all those. Prima facie, it seems there was, and there is no need for election if there is no one opposing anyone. What will they vote for? Now there is a new decision that will come. Supreme Court has said even if there are no opponents and there is only one person for one post, even then there has to be some election and then some amount of vote one should get to get the post. This is what is pending. So as of now, what we think is that if there are no contestants, then what is the need for the election? They will be immediately declared elected by the returning officer. So prima facie, what I think is that, I don't know, I'm yet to decide. I'll go through the papers again. Prima facie, the prima facie case on your behalf was lacking, I believe. And if prima facie case is not there, the balance of convenience and the irreparable injury also goes.
I don't know
But then
how
we-
Lordship is understanding. If suppose a notification is that there will be election on 3rd tomorrow in this High Court premises. If suppose this High Court premises is locked tomorrow on 3rd, guarded by police, no one is allowed to enter. Where is the question of contesting candidate coming inside and collecting
Sure.
nomination
Now
paper?
in our High Court elections also, we see now whoever is elected unopposed, we do not give vote. It's written unopposed, it's elected.
Until and unless, Lordship, that procedure is followed, if you have given the venue, at least if that venue is open, and thereafter up to 2 p.m., 3 p.m., whatsoever, as per the notified time. If no one comes, then reasonably, of course, unopposed can be declared.
Okay, let
But
me
then-
hear tomorrow, Mr. Majumdar,
Huh.
then we will decide.
Lordship.
Otherwise, I've taken your ground. It's all blocked. Nobody could enter and file admonition.
And then there are sufficient materials, evidence on record, Lordship reported.
It will go to my chamber. If this one you can give back to me. Huh? Only one book. This is 2008-11. It's okay. I have written it down. I'll take out. Give it back to him.
Hello.
It's one. Yeah, I'll take this. We can just pin it up. Stapler is heavy. Oh. Wait, what is this? Facebook India, that item number. You can keep it there or whatever. Right, I've not given. Hardin, what? Hardin part was already there. Hearing could not be concluded. Yes, Mr. So-and-so appears for the petitioner in item number
10. Oh, sorry, 8.
8.
1
And he states before this court that the conducting counsel has some difficulty in doing the case today. And as such, the court allows him to conduct the matter tomorrow. So list the matter tomorrow. Both 8 and 11. List the matter on tomorrow, whatever day.
Yes, tomorrow. Possibly at 2.
Try to do it.
Yeah, before the time. Okay.
And prima facie only, don't Mr. Majumdar, only prima facie. Yes.
It's a criminal petition on merit, Your Lordship. And in many occasions, the petitioner side will remain absent.
There are so many judgments here.
Lordship, earlier, we have placed, and in fact, Your Lordship, on the very first day itself, they have referred some judgment. Perhaps those are the judgment.
Achha, what happened? A wakalatnama filed by learned counsel to appear appearance on behalf of 2 and 3.
Yes, sir. They appeared on last occasion.
They are there.
Yes, sir.
Only the petitioner is not there.
Yes, in many occasions, Your Lordship. And CD was also returned.
None appears. Yes. It's a petition.
Criminal petition, Your Lordship, on merit, Your Lordship, for quashing of the FIR.
We'll give a last chance.
Yes.
Next date, if they do not appear, then it can be dismissed for default.
Yes, ma'am. That may be reflected, ma'am.
None appears for the petitioner on call. Mr. Ate appears for the state. It is seen. It is seen from the various orders of this court that that the counsel for the petitioner has not appeared on many occasions, and the matter was adjourned a number of times. It is therefore directed. No, before it is therefore directed, before you write, this is a criminal petition filed under section 482, filed under section
482.
82 only. This
Yes.
was before the
Prior to the coming into force of new code. Sanhita.
482 of the CRPC for quashing of the FIR.
Itanagar PS.
Not required.
Not required.
Since you write, since this application, Victoria, In this sentence only, you write, since this application was filed under section 482 of the CRPC for quashing of the FIR, there is no bar if the said petition is dismissed for default. List this matter on a day, list this matter on after the vacation on a date to be fixed by the registry, and on that date, if the council do not appear, this court may proceed to dismiss the petition for default.
Yes. Obliged.
These were also here.
May it please, your lordship.
Hmm.
Lordship, am I audible, your lordship?
Yes, yes, very much.
Yes, yes, I am appearing for the respondent, your lordship, on behalf of Orin Modi, your lordship. Before my learned friend started submission, my lord, may I point out one thing, my lord? This revision petition, second appeal has been filed from the liberty granted on the second appeal they have filed. So from the revision petition they have filed, and that was ordered by Honorable Mr. Justice Robin Fukan, your lordship. And that the judgment and
Where is
that
the file? Wait, Vanessa, where is the file? Oh, achha. That was, yes, proceed.
yes, my lord, that judgment of the revision petition, we have filed a review petition against that judgment, my lord, and that is numbered today, and it will be listed after vacation, my lord. And if your lordship permits, my lord, this matter may be taken up after the vacation, my lord, or after 3 weeks, my lordship.
So
Because
that-
because there is a question of, my lord, maintainability of the second appeal, my lord.
Okay, I'll not write anything. List the matter after the vacation.
My lord.
Or you
My lord.
want all the matters to come up together?
No, my lord. That review the review petition was numbered today and it was transferred to Guwahati principal seat, my lord. And it will be listed after vacation.
List the matter as prayed for by the councils. Yes. Take it on August. By that time, that review application might be heard. August 5. As
My
prayed
lord.
for,
My
as
lord.
prayed for by the council, list the matter on 5th of August 2025. Okay, not required. Heard Mr. Swenson, right? And his name also. Well, your name, please. I forgot.
P. Bora.
P. Bora.
P. Bora.
Mr. P. Bora submits before this court that a review application has been filed against the impugn order.
Not the impugn order, my lord. They have earlier came before this honorable court by filing a revision petition, my lord. That revision petition was allowed on 5/6/2025 by Honorable Justice Robin Fukan. Against
Yes,
that order, we have filed a review petition, ma'am.
Review application has been filed in a analogous
CRP
revision.
number 54, my lord.
Oh, in the CRP number 54.
54/2025.
Of 2025.
Yes, ma'am.
And further please that the instant matter may be taken up after 3 weeks. List the matter on 5th of August.
Deeply obliged.
For settlement. Mandav, they have entered into a settlement.
Yes.
This is the settlement agreement. Now, on the basis of this settlement agreement,
It says Miss Bamang and Miss Sorang are what? Sisters or what? No?
the
Show me the FIR.
yes, sir. FIR page number 16.
16.
Yes. Yes, married. With due respect and humble submission, I beg to state that yesterday at around 8 p.m., one Bamang Tamin.
Okay, one second. Here, with that earlier order, you write connected petition of that CRP. Huh? Review is filed. Challenging the order in a connected CRP. Number so and so. With due respect and humble submission, I beg
Yes,
to
yes, I beg
state.
to state that yesterday at around 8 p.m., once Bamang Tamin and Bamang Tare came to my shop at Papunalas, they started asking for beer, and accordingly, being a shop owner, I offered the beer, but my utmost shock and surprise that after some time, Sri Bamang Tamin, they started sexually assaulted me by touching my private parts. When I retaliated,